Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Good morning, my friends. Today is Tuesday, June 3rd, 2025, and we're back at it. We're back at the never-ending story. Neverland, upside down, inside out, matrix of the Narnia that is Norfolk County, Massachusetts, ready for day 26 of the re-persecution of Karen Reed. And we're here for it. How's everybody today? Something's really bothering me from yesterday, and I gotta talk about it with you because it's really bothering me. Something that went on yesterday in court. I'm not over it yet. I'm mad about it. And if you choose to wait on the cesspool of Twitter, you might have seen some people talking about it because I went on there just to see if people were talking about it and if I'm overreacting and if people thought that it was as horrific as I did. And that is the text messages of Proctor. During the text messages of Proctor, having Proctor's friend read actually it was Hank Brennan who read a text message out loud that I'm still highly offended by. If you thought that Hank Brennan was genuine when he became the hired gun on this case, the guy that Norfolk County and or the Commonwealth is paying, I don't know, how much money is he going to make by the time this is over? $1 million? Proctor's friend was forced to read some of those messages on the stand. And then he said, you know what, as Hank Brennan wanted him to go on. Now, keep in mind that these text messages were already entered into evidence, I believe, by David Yannetti. Yeah. So they were in there. They didn't have to be read out loud. But when Hank Brennan read out loud, because the friend was uncomfortable at one point, he's like, these are not my words. I don't want to read this out loud. When Hank Brennan read to the world the text message that Proctor wrote that said that John O'Keefe's sister's husband, now remember, this is the father of the children that John O'Keefe had taken custody of and was raising. When Hank Brennan read to the world that Michael Proctor texted to his buddies that he overdosed on his wife's grave, my heart broke. Some people say it was out there. Some people say, somebody else had broken the story a while ago. Maybe everyone, but the world didn't know that. And maybe the children didn't know that because when their father and mother both died in quick succession, 6 months maybe of each other, couple months, their mother died of, I think, cancer or a brain tumor. I'm not sure. And then it was read out to the world yesterday that the father, that Proctor said that the father overdosed on his wife's grave. Where are the grave concerns now for those children? who probably were told a story that their father died of a heart attack. That's what I thought. I mean, that's what it was out there in the public domain, that he died of a heart attack 6 months after his wife died. The children were young. How old were they when their parents died? 6 and 8, 6 and 9. If you think that Hank Brennan is looking for justice for John O'Keefe, think again. Because he just threw the O'Keefe family under the bus. That was a callous, egregious, repulsive thing to do. And the people out there who hate Karen Reed, that are on Twitter, that proclaim to be the self-appointed best friends of people like Jennifer McCabe, are out there saying, well, Yannetti wanted them in evidence. Do you think Hank Brennan is out to get justice for John O'Keefe and his family? Do you think he gives 2 rat's tails, let's say, for all of the people that are watching from hair salons, nail salons, doctor's offices, other offices, construction sites? Do you think that he gives a crap about those children? It wasn't enough trauma to force the niece to come in and testify again under oath about some things that she didn't say during the first trial. But he put that out there to the world. And they're old enough now to be watching this trial on YouTube. And if they were not aware of that, not only are they now aware of that, but all of their friends are aware of it too. You think maybe they're going to be relentlessly, I don't know, bullied, made fun of, heartbroken? Is that justice for John O'Keefe? Or are we here to disparage Proctor now? Because now apparently he wants to throw Proctor on the bus because those are his words. And are we really here about the defense of the Alberts and the McCabes? Think about that. Is the O'Keefe family outraged? Can you imagine the hurt that did not only to the children, but to that man's parents and family? To put that out there in the world? Taking your own life, I don't know if it was intentional or if it was accidental, but the rumors out there are that it was not on prescription medication, let's just say. It's not justice for John O'Keefe. It's not. And I'm so outraged by that just shows you what kind of prosecution this is. That's not respect for the victim's family. Am I overreacting? I am so upset by that. So many families who have, members of their family who take their own lives. It's a very private thing. The family has pain. People don't need to know that. People don't need to know that. And my heart breaks for those children if they didn't know that. And I'm so upset by it. I have always from the beginning been very protective of not just those children, but the McCabe children too. Why were they dragged into this? Why was Allie forced to testify? That was pretty traumatic for her. And then when that M. Michael P. Phelps or whatever the F his name was, did that podcast, and got Aiden involved and then threw Aiden under the bus. This self-proclaimed bestie of Jennifer McCabe took part in that podcast and said also to a worldwide, I don't know how many views that thing got, but said to the worldwide audience that at least 3 of the children involved on that side, on the O'Keefe Albert McCabe families, at least 3 of them had to go to inpatient and or outpatient mental health treatment. Really? Is that what you want out there too? I'm repulsed by that. And then for people to be defending Brennan and saying, oh, well, Yannetti, the defense is the one who wanted those messages. No. That's not the way it works. David Yannetti did not read those messages to the class and to the world. And now this is not about justice for John O'Keefe. Hank Brennan, the mob lawyer, was brought into this case to protect certain people. You heard it yesterday during Kelly Devers' testimony. Her life depended on what she said on that stand. How often do you think A 24-year-old rookie is called in to see the commissioner of the Boston Police Department, which has, and I looked it up.
Hear ye. All persons having anything to do before the...
You can wait because you know there's going to be a sidebar. I mean, them, not you guys. 2,000 police officers on the Boston PD. Commissioner's calling in 24, 25-year-old Kelly Dever to meet with him to tell her to do the right thing. Do the right thing. Who's being protected and who's not being protected? Think about that. I am outraged. My heart is broken, and we'll see what fresh hell awaits us today. Welcome to coming. Thank you for coming to my TED Talk.
Honorable Beverly Canoni, Justice of the Superior Court, hold an indictment within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Oh, the jury's here.
I have to ask you those same three questions. Were you all able to hear yes? Instructions in refrain. Everyone said yes or nodded affirmatively. Everyone said no or should be. Is Dr. Russell in the back there?
Dr. Russell is still on the stand
Brennan,
as
you can set
under
up if
cross.
you want to.
Obviously, Brennan has been watching on YouTube what you guys are saying in the chat and in multiple streams, I'm sure, and he's trying to be so nice to Dr. Russell this time. He apologized to her yesterday. I'm sorry for snapping at you, Dr. Russell. We know that that's not who he really is. We've seen him. We've seen when someone shows you who they are, believe them the first time.
Doctor, I remind you, you're still under oath. Thank you.
Thank you.
Good morning, Dr. Russell.
Good morning, Your Honor.
And if Kelly Dever has false memories, maybe she shouldn't be a police officer. Every case she's ever testified in should be looked into. How dare they?
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes,
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
I'm here to tell you that it is not uncommon that an attorney will revise an expert report. It's not uncommon. He's going to make the jury think it is because that's all he's got.
May I ask a question?
Yes.
Thank you.
Do you think anybody's going to tell this woman what to say?
December 22nd,
This doctor?
2024, in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
And I said, okay. And you answered.
No, I wrote the report.
And then finally, I asked, who helped you with your report? What did you tell us?
I said, Mr. Lessie.
And Mr. Alessi, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay.
Big smoking
And so,
gun.
did Mr. Alessi help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you just
please.
testified to. You want to
Yes,
see it again?
yes.
Go, sis. No doctor can ever tell
By
you
the way,
something.
between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Or did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during your
didn't. We didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I did
order
not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from
There's
court
nothing wrong with
together
that.
Attorney Alessi?
There's a driver.
Okay, who else is
Did you remember that Tully picked up your witness at the airport?
in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday. No. Not in the car yesterday. No.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver. Yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We
weather.
spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride home, back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning, other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some concept.
Did he just pronounce Alessi correctly for the first time ever?
There must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
The sage advice.
No.
Do you have any memory issues?
He just remembered how to pronounce Alessi, and now he's asking her if she has memory issues.
No.
Listen.
Do you have any memory issues?
No.
Do you have any memory issues? Here you go. Listen to that again.
It was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
May I approach?
Yes.
The judge even sounded disgusted by that. Maybe.
Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16.
There's no reason to show it to you
That
because you
analysis,
agreed.
The questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain.
That looks consistent.
You want more time with the transcript?
No.
Oh, now you're going to patronize her as an older woman? 18 Wheels, thanks for gifting 5.
Has
Private
anybody
info.
else talk to you about your testimony today overnight?
Private info gifted 20 memberships. You guys are amazing. I love you.
Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes,
May I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that. Disregard.
Wow. Jennifer
May I approach?
McCabe.
Yes.
Every single witness. Show it to me. Show it to me.
23.
Taxpayers of Norfolk County, Massachusetts, this is what you're paying for.
2024, Doctor?
June 21st.
Thank you, Cat's Meow. And on
Page
top,
23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you.
Yeah, that was the question Lally
Yes.
asked her.
Thank you.
That was the question that Lally asked her in June of 2024 at the first trial.
When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it,
Sure.
that sentence?
Sure. Go right ahead.
No, you, I'm sorry.
Okay.
I'm sorry, please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty, the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there's some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes,
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you describe methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. DeMunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
It's based on her decades of experience and the number of wounds that she's
And so
treated.
with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make and nurse practitioners and the like make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on
Neither
dog
is
bites, if you
she.
would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
Yes.
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the and the articles that I read, the numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out, you sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like to put up an exhibit of Mr. O'Keefe's arm.
No,
Ask you some
I
questions
can't
about it.
play it.
You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Superficial.
Yes,
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
yes,
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
grouping number 1, yes,
Number 2,
yes,
number 3,
yes,
4,
yes.
5.
Which did
I'm
you call
sorry, this
4?
one,
4,
5.
5, 6, maybe.
Okay, so as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Sustained.
I will be taking the arm pictures off the screen because YouTube has deemed them too graphic to show and unfriendly to advertisers. And so therefore they will not be on the screen. If that offends you, you can find these arm pictures anywhere else that you like. You will be able to hear the testimony, however. So listen, as soon as the arm is off, I'll put the screen back up.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe so,
course.
but I'd have to see the
Do
transcript.
you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
So do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion,
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No,
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in
She's
totality.
shaking her head like,
I disagree with that. I believe that in the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty, you're not sure. What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder,
Mhm.
right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, at the end of the paw. They come to a point. And by the way, the paws can open and close. So the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you,
Point is this, it's a dog, not an exploding taillight. Do we need to remind you so quickly that Dr. Welcher has no idea how fast Karen's car was going when that arm shattered that taillight? Doesn't know where the car was, has so many details that he doesn't know. He wasn't given the information. He just doesn't, nobody knows. It's a dog, not a taillight. That's the important part here. He's grasping at straws, not just straws, but wet paper straws. I hate paper straws. Anything is possible. A doctor can never say something with 100% certainty.
do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
Good. Just like every single one of your witnesses did. You might have some room to scooch here.
Yes.
Testified on June 18th, doctor. You were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin. And you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
She did say that yesterday.
I'm going to actually keep your voice up, okay?
Okay.
Look at Brennan's smirk. Now he's going to treat her like a dementia, a grandparent with dementia.
Testimony last year, yes?
Yes.
The photos are too graphic to be shown on YouTube for this channel. Sorry if that offends you. If you want to go see them, you can go to Court TV, you can go to Law and Crime.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes,
after your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
no,
He's got nothing. He's got nothing.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
no.
Are there different types of teeth in a dog?
Yes,
Okay. The pointy teeth, the big ones, those are called canines,
correct,
and the smaller ones are incisors.
correct,
There are 6 incisors in a healthy dog on the top and bottom between the canines.
correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information?
Aren't canines teeth? Or am I missing something? I'm getting complaints about my volume. Can you let me know if my volume is too loud for you?
About photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged. And each time I reviewed the case, I became more certain that these were from canine teeth.
So
And actually, there's other marks there, but these are from teeth.
you say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Canines are teeth.
Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
Were you allowed?
Do you remember that conversation? You said that the point of entry would be the bigger circle, pull this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that
Don't
at
remember
all.
that conversation
No.
we had? Okay. And so inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound
Yes.
up there, closest, I agree. Yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound,
If you're looking at the arm picture on another screen or another device, he's going from the top, the wound at the bicep, he's calling number one, the one next to it, he's calling number two, he's going down the arm towards the wrist.
alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me, yep, four,
Mhm.
same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for five and same for six.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number two, what caused this wound, Dr. Russell?
Number two, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny
Punctate.
pinpoint almost lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds
The
separately
overall
so we
pattern.
understand what you actually recognize with the methodology and what you don't. So looking at wound number two, based on whatever methodology you've been using,
Remember also that he's going to call a veterinary scientist who's not a medical doctor to testify about these dog bites, maybe in his rebuttal case.
are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these two scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting
do.
that not exact, these two linear abrasions, just like 1 and 2, are you suggesting the canines cause these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
I'm going to object to the word that you used.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay.
Now he's being
Did
rude
you
to the judge.
testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
She asked for, Crystal says she asked for a transcript
May I
yesterday
approach?
too.
Hold 1 second. Could you please turn the fan off?
They're turning off the fan.
Jerry, is it okay if we turn the fan off so we can hear better?
Interesting how they can afford to pay Brennan $1 million. They can afford to pay Aperture $400,000, but they can't afford good air conditioning in the courtroom or quiet air conditioning or something
From your
better than a
December
fan.
hearing, page 100, line 5. When you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth. Weren't you asked specifically about that on page 100, line 5?
The dog bites didn't kill him. Remember that too. Oh, the judge
Yes.
is yawning.
But may I read it?
Sure, I'll read it with you.
Okay.
He tried to grab it from her. And she said, "May I read it?" Watch this. If you weren't looking, watch the judge cover her mouth with a yawn.
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. One of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm
Incisor.
not sure on the second set, so this is the set just above the elbow.
He doesn't know how to pronounce incisor, and he doesn't realize that the canines are teeth. Are you surprised? Incisors has been here from the first time he mentioned it. He learned how to pronounce Alessi today, but he didn't learn how to pronounce incisors. Just put a pin in that.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder. And then the sentence, but I'm not sure on the second set. So this is the set that's just above the elbow. I said, I'm not sure.
And then, sorry.
Oh, go ahead.
You do?
Oh. Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
Good. She explained herself.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim.
Which piece of the taillight injured which piece of his arm, Mr. Brennan? Can you give us an expert that will tell us that? There's 47 pieces of taillight. Which specific piece of taillight injured which specific part of the arm?
At the last hearing is this was from teeth.
That's what I believe.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You were
Yes.
asked, what do you think? And you didn't say with 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
It's the pattern that indicates a dog attack, sir. What part of that don't you understand? A mauling, as it were.
What tooth do
By
you
a
think
dog.
caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two are caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing,
Oh,
Dr. Russell.
Did you say strike or strike?
Strike with a K.
That was the court
Look at the
reporter
spacing,
asking.
Dr. Russell.
Mhm.
A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines?
Incisors.
Is that your opinion?
Oh, he heard
It's
me.
possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I
The
did.
posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy
That's
part of the
exactly
arm?
what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes, and coincidentally, every single one of them lacks any wound to the underside of his arm?
Yes,
Your claim is that a dog penetrated the sweater on the top.
It's not a
The
sweater.
lower jaw did not leave any wounds.
I'm claiming that that's not what I'm claiming.
Was he wearing a sweater, chat? Would you call what he was wearing a sweater?
No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your,
Nobody saw the dog attack, allegedly. Just like nobody saw the body or the car accident, the alleged car accident.
your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, can you put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Let's look at the
I'll
clothing.
bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be,
Well, do you have the
Specific.
opinion today? And I'm getting the transcript for you, Dr. Russell.
thank
Do
you.
you
Boy.
have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. So a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
It wasn't a car accident.
Strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
It's the pattern that makes it a dog attack. What part are you not understanding, sir? Thank you, Remy. Praise be under her eye. Have a fun on your cruise, Mike from Providence.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
Not individually, but as a whole. Unless you'll clean it up. This is what an honest witness looks like.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends, it depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it?
Again,
Objection, Your Honor.
So there was a question with that, so I'm going to let that.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did
measure
not.
them? Did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Because the medical examiner, the only person to have examined the body, did not take measurements. And Crosby, the Commonwealth expert, used the hospital band on John's wrist to make his approximate measurements.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, Doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential
A lot of
diagnosis.
questions.
You remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So if you're-
methodologies.
if you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes, I don't know how to answer that.
Well, try.
Can you be more specific?
Good.
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that
ain't
forms a basis for me.
Do you really
Quinn.
think?
Did you finish that answer, Dr.?
No.
Did I cut you off?
Yes.
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case,
Yes. Yes.
I didn't have a lot of information. That's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident and
Yes.
investigation, yes.
Have you ever
It was probably more rigorous than Trooper Paul.
testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene
Go
of a
girl.
car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Thank you,
Okay.
Laura.
Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes,
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors.
Have you
Yes.
studied that before you gave this
Studied.
opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And
photographs.
when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
Human arms still can't shatter a taillight. That's polycarbonate.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations
Oh, good allegations, I was going to say.
of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around?
Fastly? How fastly it was going? No, and you know who else doesn't know? Your experts. Because last trial in season 1, you said it was 24.2 miles per hour, 60 feet in reverse. This trial, your expert, Dr. Welcher, has no idea how fast the car was going. He says at least 8 miles an hour, and this time it's traveled 87 feet. This is humorous.
Slowly or fastly, Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the
Hold on. At around the time that you say these wounds happened, she hasn't given a time that this dog attack happened. Did I miss that part? Is he falsely stating her testimony here about how fastly the car was going and what time these alleged injuries occurred? She did not say what time they occurred. Right around the time that you think these wounds were caused. Again, he is misstating her testimony. That is not accurate, but this is what he does. And play it again for fun.
of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body
It was a
first
dog
landed on
attack.
that
It doesn't
ground?
matter.
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow.
There's a
The
picture.
ground, the cold, hard ground. Did you see anything
Un-
that said that?
Yes, I saw an area of grass
Have you
in
ever
the
looked
picture.
at, have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at
I
the
don't
pants?
know if I looked at the pants.
So
To
when you
tell
say
you
you
the
didn't
truth.
see any evidence, are you saying you didn't look or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pant photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see
Objection, Your Honor. Can we approach?
as much information as
So
possible?
let's,
He's badgering.
we'll come to sidebar.
This is called badgering the witness. She saw the clothes in a pile on the floor in the hospital. So did we all. I saw grass stains on the back of his pants, indicating that he was dragged. If he was thrown and did a pirouette and landed on the grass, on the ground, in enough snow to track a cat, would there be grass stains on his pants? On the back of his butt? Would his pocket be ripped? I don't know. I still have more questions. The longer this case goes on, the more questions I have. Chain of Fools is definitely on the playlist. Brendan will have an expert
Dr.
on the
Russell,
shape of dog
before you
bites.
gave your opinion to this
Maybe.
jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from
Was there any dirt or gravel in the wounds? Was there any plastic shards of polycarbonate taillight in the wounds? You want to go there? You want to say this was road rash? Okay. Hopefully she'll pick up on that.
the photos? Were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes?
Because those photos were not taken until the next day, after more snow had fallen, many of them at night after another 18 inches of snow had fallen.
Right near the area where Mr. O'Keefe was found, bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those?
There were no photographs of where Mr. O'Keefe lay. We know that. You know that. We were here for season 1, pre-trial, pre-production, post-production, there are no photos of where his body was because nobody took them. Again, he's misleading the jury. Those photos do not exist. Nobody measured it. Nobody put little evidence markers out there. There are no photos of where Mr. O'Keefe's body lay. Officer O'Keefe, by the way. So
Bushes.
again, he is misleading the jury. Listen to that again.
Right near the area what the makeup of the ground was.
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe
Bushes?
was found? Bushes with branches. Did you know that?
Not very close, no.
Are you changing your theory again? Now it's branches that caused the arm wounds? Okay, now it's branches, guys. Got it? Branches and bushes. Scratched up his arm. Good. His theory is evolving. Because no one's buying the exploding taillight theory.
Did you see the bushes in the photographs near where Mr. O'Keefe laid?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
None of
Do you
them.
have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with a vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
That was a stupid question for
When
him to
you
ask.
considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
What?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
We're not talking about an accident where a car rams into a bunch of people on the sidewalk. That's not what happened here.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are there instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries. Correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that receive injuries from broken plastic or broken glass in a car?
Yes. Many times.
And when you've seen them,
There's no glass on that car. There's no glass in that taillight.
have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes. I considered multiple scenarios.
Had you, or do you agree that injuries from a sideswipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you con-
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact.
Thank you.
There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You're good.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
An
Debris.
object?
Debris field, yes? Did you look at the debris field in this?
An object and a person are not the same thing, sir. A person is not considered an object. I don't know. Is it? A pedestrian considered an object? A debris field. Here you go. Here goes the debris field. He promised the debris field. I don't know if it was in his opening or pre-trial.
Great.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries,
Amen,
lining up
sis.
in a certain fashion to cause those regular striations.
Rather
Amen.
than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian. Yes.
Not as a police officer. Never seen
Not-
anybody knocked out of their shoes. He's opening the door now for her to be able to talk about police procedure. And I'm here for it. I hope that Alessi busts right down that door because he opened it. You want to go there, dude? He also opened, the door to the injuries not being caused by a car accident, which I don't think she was asked on direct, was she? These days are blending together. Here you go.
That morning.
I did not.
Have you ever, as a police officer looking into car collisions, ever hear the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian. Yes. Not as a medical expert.
Can I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off, correct?
Were you aware that it was wedged right up against the curb? Were you aware of that?
I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No,
Could I have exhibit 99D, please? In
Slinky,
your
thank
study
you.
to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
no.
Do you see underneath that hat, there was not 2 inches of snow? It looks like dirt and
You can't see anything
grass.
under the hat.
Yes,
You can see some
When
straw.
you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
Wait a second.
It
You're saying now
could-
he was found under 2 inches of snow? Before you said he was found with grass underneath him. Which is it? I want to hear that again.
be.
He was grass. See underneath that hat, there was not 2 inches of snow. It looks like dirt and grass.
Yes,
When you gave the opinion that he was on 2 inches of snow,
I see
would it be
ponytails.
important to know whether or not he fell directly on the hard ground or on snow?
it could be important. However, it could be if the ground was frozen. If it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the detail. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No,
In the foundation of your opinion that a collision or impact did not cause Mr. O'Keefe's wounds on his arm, was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes,
Was it important to time when that taillight was broken?
what do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes,
Early morning hours.
yes,
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
it was important to know. I still don't understand the question. I'm having a trouble
Okay.
understanding the
It's my
question.
fault. I'll try to ask it a
If the taillight didn't make the injuries, then it doesn't matter what time the taillight was broken to her. She's not the police investigator here.
different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes,
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle. Yes?
that's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes,
And you learned that her right rear taillight was broken and missing pieces. Yes?
yes,
Did you want to know if there was any evidence depicting when that taillight was broken? In considering this conclusion,
yes,
did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
No, there wasn't.
I'm going to allow that.
What?
Not at the time, but I expected that if
That is not accurate. That is a misstatement of the evidence. That is a lie. That could be an altered video. There is no evidence that there are photos of it. Hold on a second. And the judge is allowing it under her eye.
Broken. And considering this conclusion,
yes,
did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
That video does not show that tail light was missing pieces. That's the ring camera video after Karen backs into his car and she leaves and goes out the driveway. That video does not show that there is missing pieces from that taillight. And the fact that the judge is allowing this right now, that is a fact for the jury to decide, number one. The fact that the judge is allowing this, number two, my head has popped off. It is rolled. It has gone across the Long Island Sound to Connecticut, and the fix is in.
I'm going to allow that.
not at the time, but I expected that
There's no video of
if
that.
there were a collision, that there would be pieces of the car, a car involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time?
A broken taillight in and of itself could not cause those injuries. There would have to be
Thank you.
multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation,
Better want what you wish for, Hank. You better want what you wish for because you just got it. That could not have been caused by a taillight. Thank you, Becky, for gifting 5 memberships. Let's hear that again. A little bit louder for the people in the back.
to rule out,
So it didn't really make any difference.
when you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's
He's
That's,
trying to shut her up.
why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03
Not what
a.m.
it
that
shows.
morning?
Would that be, I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10,
It does not show pieces of the taillight missing.
it actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we
car,
have
the vehicle parked, yes.
Exhibit 11, please? Did you
There's no
consider this
metadata.
picture in your differential diagnosis?
I
Where's
didn't,
the
I don't know
objection?
that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, they'd have these pieces would have to be lined up in a certain configuration.
Why was
in
there no
order
objection to
cause
that
those
question?
wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case, you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision. Do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No, what do you mean?
Well, have you seen
Well-
any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about? Did I hit him or something of that? I don't. What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact or collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction.
Oh, yes.
It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments?
Praise be. Onto her eye. Mic drop. He opened the door to this. An acute grief reaction can cause people to do crazy things. I've seen it many, many times. They often blame themselves. Thank you, doctor, for getting in testimony that maybe some other witness was not going to give the jury. Thank you. Say that again.
Finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Any more questions?
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have exhibit 147B, please?
The wounds were never swabbed.
On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. Like to approach, please.
Facts not in evidence. Facts not in evidence. He has not brought out the expert who swabbed that shirt. He should not be allowed to get into this line of questioning, and he knows it, and that was improper, and it should be stricken. He has not proven that. He has not brought in one shred of evidence yet about that. Oh, Paul O'Keefe, something funny, Paul O'Keefe? A little time to, a little room to scooch here. She better not allow it.
What we will give you the morning while you're sitting here. So it's taking longer than any of us wanted to do while you're sitting here. So we're going to continue what we're doing, but we will give you
Good.
the morning recess. So that's about a half an hour. or something, okay?
Half an
All
hour.
rise for the court, please. Close your notebooks, follow me.
All right, a little behind. We can scooch.
Jury is exited the courtroom, please be seated.
The closed captions just said, oops,
Jury is exited the courtroom, please be seated.
during sexually the courtroom, please be seated.
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you.
Yeah, he's getting ready. Give him a minute.
Excuse me, Mr. Brennan. I'm going to go to the podium. Your jury is there. If you'd like to-
Mr. Brennan, can you remove? Oh, okay, it's being removed.
Oh, the judge is sighing. We have a sigh emoji for that. I feel like someone stuck an ice pick in the side of my head.
Thank you, Your
It
Honor.
will not go away.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial
Yes.
with prejudice.
Yes.
A mistrial
Yes.
with prejudice.
Go.
There has been no mention in this trial of DNA with regard
Yes.
to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and caused and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made, that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it.
Right.
The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial. As Your Honor has admonished several times, what happened is, this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable.
That's right.
That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial.
Right.
And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
If you're just joining,
Thank you.
Hank Brennan intentionally brought up dog DNA in the questioning of Dr. Russell, and the defense is moving for a mistrial with prejudice.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe.
It doesn't matter.
Clear. The defense is on notice that we were not going.
It doesn't matter. There's no evidence in front of the jury, and you just put that out there intentionally, and you need ramifications for your behavior, sir. This is not the way ethical attorneys act. This is not the way ethical prosecutors act. You are wrong. Who knows what she's going to do? But this is outrageous, and you should be outraged.
Going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal.
You knew they were going to come out with the dog
It
bites.
is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it. She discounted it. She created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper.
Inconvenient?
It's not unconstitutional. It's not irrelevant. It's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and
Not about words, dude.
because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Wilson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case.
Right.
Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds to the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with a consequence of its action. This is remediable, and I respectfully submit
Irremediable.
warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
I have 30 seconds.
Sure.
Do you have grave concerns, Judge? Are there any grave concerns now? Hello? Shout out to the grave concerns.
But they can't. The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12th, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words,
What page?
we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour. So
With prejudice means the case gets thrown out and the charges get dismissed and they cannot retry her. That is what a mistrial with prejudice means. She's going to take a half hour because she's got to make some calls and she's got to put an APB out for her grave concerns. This is a big time error, in my opinion. If he wanted to bring up the dog DNA, he would have brought it up in his case in chief the way that Lally did during season 1. If she doesn't dismiss this case, it could be reversible error. She needs to go make some phone calls. This is outrageous. My eye is twitching and you should be outraged. And this is what you get when you hire a guy like that to come in and defend people instead of looking for the truth. He got sloppy. And she needs a half an hour timeout to go figure out what she's going to do and what the ramifications of her decision are going to be. Just like you saw Kelly Dever yesterday on the stand talk about what the ramifications of her testimony were going to be. My life depends on what I say on the stand. My job depends on what I say on the stand. The police commissioner of Boston PD called me, a rookie, down to his office alone to tell me Boston PD's got my back. Do the right thing. Winky wink, noddy nod. Blue wall of silence. This is how it works. If you're just tuning in, welcome. Let's rewind for those of you who didn't see what just happened. We'll see it. We'll watch it again. We'll see what Brennan did in his examination of Dr. Russell that
Suffer from
caused
what's called an
Alessi to go nuts and move for a mistrial with prejudice. Let's get to it. He's examining Dr. Russell. He's going way beyond scope, but he's been getting away with it this entire trial. You've watched it. I've watched it. We've all been here. Let's see the question that led to this explosion. We're taking it back. Here we go.
Different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
The fact that those holes in the sweatshirt were swabbed for dog DNA was not brought up yet in this trial. It was not brought up at all during the Commonwealth's case in chief. And for him to now bring that up with this witness when he had every opportunity to call Terry Kuhn the way Lally did in the first trial. Remember, in season 1, in case you weren't here, the Commonwealth hired an expert from the University of California, Davis. to testify that one of the MSP crime scene technicians who has already testified in this trial, do you remember who it was? Was it Maureen Hartnett? Took something like 2 Q-tips, swabbed some of the holes on that arm, some of them. She's not even sure which ones she swabbed with the same 2 Q-tips, put them in an envelope and mailed them to this expert at the university, at UC Davis, University of California, Davis, where they have, I guess, the most highly regarded veterinary DNA lab in the country. It took forever for them to get those results back. I don't remember exactly. You guys can collaborate with me on exactly when pre-trial they came back with those results. And Lally, to his credit, in his case in chief, called in, first of all, questioned, I think it was Maureen Hartnett, on her swabbing of, thank you, Mary Lou, on her swabbing of those holes. And she said, I didn't know how to do it. It was the first time I ever did it. And I think she said, even said I had to call Terry Kuhn at UC Davis to ask her how to do it. Terry Kuhn came in and testified that she got the Q-tips in the mail, she tested them, and she did not find any dog DNA, but she did find pig DNA. And again, she said, I wish they would have sent me the clothing or something like that. I'm summarizing, because I would prefer to swab the clothing myself. Many people have theorized that this clothing may have been washed. I don't know about that. There is no blood around any of those holes, even though the arms were real bloody. I didn't show you the pictures today because they're too graphic for YouTube. And that was all done season 1 in the prosecution's case in chief by Adam Lally. Brennan had Maureen Hartnett on the stand. He did not ask her anything about swabbing that shirt for DNA, for dog DNA. He had every opportunity to do it. He had Terry Kuhn, again, also on the witness list. He did not call her. He chose not to call her. And he knew full well that Dr. Russell was going to come in and talk about dog bites. And yet he did not elicit that evidence from his own witnesses on his case in chief. For him to now bring that up in front of this jury in the second trial warrants a mistrial because he didn't do it. That is his failure. And he's asking for a mistrial with prejudice here, Alessi is. And a mistrial with prejudice means, Judge, you need to dismiss this case because there is no other remedy with prejudice so that she cannot be retried. You did need to dismiss all the charges. So listen to the argument that came after this. They immediately go to sidebar. They immediately go to sidebar. The judge sends the jury out for a break, says, we need a half an hour here because it's going to take a while. And then we're going to listen to.
All right, Mr. Alessi, I'll hear you.
This is the argument. Playing it again in case anybody's just tuning in on the breaking news.
Mr. Alessi, I'll hear you.
Thank you, Your Honor.
He needs a minute. Let them huddle for a sec.
Excuse me, Mr. Brennan, I'm going to go to the podium and your area there. If you'd like to-
Mr. Brennan, can you remove? Oh, okay, it's being removed.
He said, I'm going to go to the podium and you left your stuff up there. Okay, hang on. Here we go.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened is, this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, and then Brennan gets up.
Mr. Brennan.
This happened already. We're replaying it for those of you just tuning in.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA
Doesn't matter.
in the sweater of John.
You know who's not? The jury. And now you put it out there. You can't put the toothpaste back in the tube. You can't put the genie back in the bottle. You did that intentionally.
O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it. She discounted it. She created false theories about the potential destruction of it, but she did test.
The difference here is that you have not proven the absence of dog. The burden of proof is on you. You are, in this case, you are the prosecution. We know that you usually represent defendants, but you now are the prosecution. You did not bring in any evidence of that. And so, in my opinion, she should grant the mistrial. Will she do it? Probably not, because we've seen the way this goes here. Could the defense potentially file an immediate interlocutory appeal to an appellate court to stay this trial pending resolution by an appellate court? They could. Let's see what happens, because the jury's on a half an hour break while she goes out and finds her grave concerns.
Testified this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they...
Inconvenient and hurtful? There is a woman that you are trying for murder for the second time when it's questionable that she was even acquitted of the murder charges. You are trying a woman for the second time. You have bankrupted her. She has lost her job. She has lost her retirement accounts. She has lost everything. Her attorneys are now working for free. You think this is hurtful and inconvenient? Wow. Just, you have zero ethics. Zero. In any other courtroom in the United States of America, this would not happen. This is outrageous. You should be outraged.
Trade for this jury yesterday, but it is not improper. It's not unconstitutional. It's not irrelevant. It's very relevant. It is powerful evidence that the common...
Then you should have brought it up on your case in chief, because it is your burden to prove this case. The defense has noticed you of 2 expert witnesses that are going to come in and testify that these are dog bites, sir. You had the opportunity. You didn't do it for whatever reason. And you have to suffer the consequences, Commonwealth, not the defendant. This is unconstitutional. This is against everything that we believe in here in the United States of America with regard to a fair trial. And you need to face the consequences.
Has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what
words they choose. You are questioning a defense expert about facts not in evidence, about facts that you chose not to put in evidence. You cannot claim surprise that the defense is claiming that these are dog bites, sir. The defense does not get to choose your words. That's not what this is about. He completely misses the point. He has no idea what he's doing or talking about. But we have seen this judge rule unfavorably against the defense a million times. I've seen this film before, and I didn't like the ending. Let's see if the ending is going to change this time. I don't have high hopes, but we'll see.
Parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions.
Her bias?
Where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Wilson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds to the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
I have 30 seconds.
Brennan gets up again.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making
I'm
false
pretty sure
claims
that's
about
not what he said.
everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12th, 2024 transcript. I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are
Alisi.
more. There are
Back to
more,
Elise
but
now.
that is enough for the court to understand that the representations are wholly mistaken by Attorney Elise. Wholly.
All right, thank you. We'll give everybody a half an hour.
He was pronouncing his name Alessi for a little tiny bit, and then he went back to Elise. It was just about, what? How many minutes ago? 25 minutes ago? Maybe they'll be coming back. Maybe she'll be coming back soon. Schillinger was always present daily, yet today he's suspiciously absent. Do you think this was premeditated on Brennan's part? That's a great question. Schillinger is the appellate attorney for the Commonwealth, and I don't know the answer to that. I don't know. But I can't really see if he's in the entire gallery right now. Thank you, Christine. Trooper Paul's reports could not come in during this trial. DNA certainly cannot, says Glamassus. He had every opportunity to bring it up on his case in chief, and he, for whatever reason, chose not to. And he intentionally said that in front of the jury. And I don't know that that bell can be unrung. I don't know. Is it grounds for an interlocutory appeal? It may be. It may be. Is the appellate attorney for, who's the appellate attorney for the defense? Marty Weinberger? Betterow tweeted 12 minutes ago. Brennan's too cute strategy of deliberately concealing anything bad, in quotes, in his case in chief, Proctor, the Alberts, Higgins, and yes, anything related to Chloe the dog has become a serious issue. There is no evidence of a dog DNA test, let alone the results or how and where it was collected before the jury. This was a calculated choice by the prosecution, but Brennan just basically testified as an unsworn witness by suggesting that evidence exists as part of his effort to discredit Dr. Russell. Will the judge order a mistrial? Of course not. But what is the remedy here? Telling the jury to ignore what they heard? Past experience tells us that it is probably all she will do. Did Brennan have a false memory of the DNA coming up in his case in chief? That's a great question. Well done. Everyone, let's manifest this. Let's manifest it. Manifest it, everyone. That's Betterow's opinion. Take the long way home. Never, never. In my opinion, if she denies this, it reaffirms my thought that for whatever reason, she has no way out. Thoughts? I don't know what's in her brain. I don't know what's in her brain. I have said that my opinion is that this, whatever is going on here, is way deeper than the Karen Reed case, way deeper. People from Massachusetts will tell you that they have known for decades how corrupt perhaps the police departments in this area are or have been rumored to be, let's say. And whatever is going on here, the FBI is involved and they're investigating. They just arrested and indicted the former sheriff of the Norfolk County Sheriff's Office, who I think was in charge of the corrections department. He's been indicted on felony charges of extortion for forcing 3 employees of the corrections department, maintenance people, to come to his house and work on his boiler at his house. He's facing more than 60 or 80 years in prison because of that. Why is the FBI there? What else are they investigating? How deep does this go? We saw, if you were with me for pre-production of season 1 of this mishigas of a thing, trial, persecution, how frantic Michael Morrissey, the district attorney, got in the letters that he was writing to the U.S. Attorney's Office and Josh Levy, begging to know what they were investigating and why people were getting, why the witnesses in the Karen Reed case were getting subpoenas to testify in front of a federal grand jury. And then he released that video hostage statement in August of 2023 after Commonwealth's motion for a gag order in the Karen Reed case was denied. Something's going on. It's way deeper in this than this case, in my opinion. And the hot mic is picking up some subtitles that have something to do with baseball. Hold on, let me just. So at the best practice, Came a little bit, well. And so I don't know what, I'm not going to accuse her of being involved in anything. But something's going on here that's a lot bigger than this case. Welch and Mikey D's new mascot. I know why Hank is okay. Thank you. Nico, Commonwealth wants a mistrial. So the McCabe's and Alberts go free and continue to blame Karen Reed. He argued strenuously against a mistrial. There are so many stories. People say this is very, very deep. It goes very, very deep. Think nothing but good thoughts. Just manifest it and we'll see. The transcripts that he brought up were from December of 2024. So what was that? December 20, that was the voir dire, I guess, of Dr. Russell before this trial. Okay, so Bob Alessi questioned her about the absence of dog DNA in case the prosecution brought that up again and called that witness that she could testify against it. No, I didn't say it was the Norfolk County Sheriff. I think, Tommy, it was Tom Brady, the former deputy superintendent, but he was employed by the sheriff's office. He had to do with the Department of Corrections, right? From Norwood, and his name happens to be Tom Brady. Yeah, we went over the indictment the other day on the stream. Yeah, and Remy says we learned yesterday it also was the police commissioner who called this rookie into his office to tell her to do the right thing. We've got your back. My eye is twitching. Okay, Kentucky Karen C says, I thought I couldn't be more disgusted by Hank. It's heartbreaking to see this blatant corruption. The world is watching. The world is watching. Will she do the right thing? Remember what happened in New Mexico at the Alec Baldwin trial? When the judge, what's her name, Mary Marlowe Summer, threw out Alec Baldwin's case, dismissed that case with prejudice because of the failure of the special prosecutor.
You are unmuted.
To dismiss the case, to turn over evidence. Here we go. She's coming back. Let's see.
Please be seated for the session.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Wow.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation.
Regarding Dr. Welcher's opinion, this is not about a fair trial for Karen Reed anymore, you guys. This is about covering up and protecting other people. We saw that yesterday when Hank Brennan said in open court, told the world that the children that John O'Keefe was raising, his sister's children, that their father overdosed on their mother's grave. That was something that was not public. This is not about justice for John O'Keefe. This is about protecting other people. And if you weren't sure of that before, tell me what you think now. Listen to this. Not only is she denying the mistrial with prejudice, she's going to allow this line of questioning about the absence of dog DNA, despite the fact that the Commonwealth has not even shown any evidence of it. Wow. I mean, wow. Let's play her ruling again. Here she comes. Didn't take her too long, did it? Nope. Nope. Where's the nope emojis in the chat?
Session.
Yeah, this is
All
her
right,
ruling.
so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan,
Rights
you
are
can
saved.
continue with this line of questioning.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Dr. Walsh?
Yeah. I don't see it without a foundation.
It's Dr. Walsh.
So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
It's Dr. Walsh's opinion.
Yes, but not right now. They're on their way. All right. Do you have enough?
I'll work around it.
Okay.
working around it.
Your Honor, I would object to being done outside the jury, that it should be done like I've had to do with several witnesses in front of the jury.
Okay, if that's what the defense wants. Are you sure, Mr. Alessi?
Oh, wait, I'm sorry, let me confirm with my.
Oh, she sounds real nervous, that judge.
Yes, Your Honor, we are going to.
Oh, dear.
Thank you, Your Honor.
Okay.
How are her rights saved?
They're on the way, Your Honor.
She's on trial again for the second time.
I'll be done very quickly, so I'll have to make that decision.
Is the lunch? Are the lunches here?
Are the lunches here?
I'll.
Hold on.
I'll
We're a little tiny bit behind.
are they still over there?
Are they still over there, the jury? It's all about the jury. It's not about the defendant.
They are.
Did you start yet, or can you?
I just, if they're downstairs on their way up, I don't want to stop them.
I could do it in 2 questions.
It's a flight of stairs.
Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, but subject whatever Your Honor does. Based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects Your Honor's schedule.
Oh, he's got 30 minutes
I
to
just didn't want to
redirect.
stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it.
All right, we'll do this now.
Be quick.
Okay?
They're asking for, I think they're going to do some sort of voir dire, and I'm not sure of what. And so,
Dr. Russell, during the
Oh.
review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here? Tony?
so there's a line of questioning that Brennan wants to get into
Dr.
about
Russell, did you ever review and receive that document from the defense?
this Dr. Walsh's opinion. So they're doing a voir dire.
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard. I disagree with his assessment.
Thank you. So I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it and I was not allowed to pursue questioning. So I do not believe under the standards that's been set in this trial that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're the only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Alessi?
Thank you, Your Honor. My response is this. I'll give 2 quick examples. Dr. Welcher, Trooper Paul, Dr. Squirty Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Squirty Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark.
Okay. All right, thank you, Hunter.
Thank you, Hunter. Okay, Betterow just tweeted, folks, this issue was never going to lead to a mistrial, however improper Brennan's questions may have
In
been.
Evidence now?
She should have precluded further inquiry on this because the defense cannot challenge the evidence, credibility, and reliability surrounding the DNA testing, and they shouldn't be obligated to call the witnesses and make this an issue. But as you just heard, she's going to allow this line of questioning to continue. Okay?
The DNA. It's not, right?
It is not.
Okay.
Is there a question?
Yes.
Wait.
It's not yet. It will.
An objection. Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
Not yet. In evidence.
The DNA. It's not, right?
It is not.
Okay.
Is there a question?
Yes, it's open. I denied the motion and allowed the line of inquiry.
Okay, now we're waiting for the jury to come back so that he can continue now to question Dr. Russell on the absence of dog DNA.
Jurors, I
despite the fact that he
appreciate
never
your
brought it up.
patience. All right, Mr. Brennan.
We're in an alternate universe. We're in an alternate universe. And we're still on the cross of Dr. Russell as we wait for the jury's lunch to
Dr.
arrive.
Russell?
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of, which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was.
Oh,
some
that one,
Do
yes.
you remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or?
No, I was
Suggest-
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree.
Again, she
that
did
a
not
side-
say breaks, lower body breaks, just the lower body injuries, bumper marks, bruising, not breaks. He's mischaracterizing her testimony. Am I the only one picking up on this?
the car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body breaks, do you have any studies about the frequency or the likelihood of lower body breaks in a clipping impact as opposed to being directly run over?
No,
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
With the blue paint?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and
Yes.
showed
Yes, we did see it.
the
Yes.
height and the location?
can't unsee
when
it.
It touched Alexis, did you see that?
We can't unsee it. We've seen it. It's like a Nickelodeon slime experiment.
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a
She's
car,
back.
how fast, how slow, acceleration. Did
You're
you
just
look at
telling
any
her
of
now
that
what it is.
information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different, or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it. And I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions. And so therefore there would be reason for either skin cells or
Mhm. Thank you.
DNA or possibly other, hair, fabric to be on that car.
That's right.
So when you
Well
consider
done.
testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, could we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve. Yes.
Having an interest in dogs, in dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it, excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items, sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the
Years.
death. And there were images of clothing on the emergency room floor. So yes, I am aware that there was some swabs taken at some point.
Is that gratuitous answer part of your advocacy or a part of your medical objective?
Gratuitous answer.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, and giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes,
In fact, what was found was pig DNA,
that's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog, prove it, John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes,
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
yes,
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
So the objection sustained. You can ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA. Yes?
Yes,
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why. And you want to know, was the test done correctly? You know, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident.
Of the
So there was
wounds.
a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner,
There you go.
weren't you?
Yes,
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
yes,
Did you know at the time Dr. Scortabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
yes,
Did you know that claim didn't come about until over a year later?
no.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
yeah.
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds.
There's no investigation.
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
Oh, yes, I can.
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
Pregnant pause by Brennan.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you
Sweater.
expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
No evidence of that either.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments
Again,
of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
I'm just going to allow it.
Did
Just going to allow it
consider
like
that?
it's
I
fact.
didn't know that at the time.
Could we have 201D, please?
Like it's fact. Like it's fact that there was taillight found in his
Dr. Russell, this is a
Shirt.
photograph.
Please. If you had any doubt that we were in the land of the lost, we are in the land of the lost. That is a question of fact for the jury because I don't think that it's been proven that there were shards of taillight embedded in the sweater that was in the same bag with the taillight that was collected off the floor of the hospital, thrown into the back of a truck for a couple of weeks. And when was the swab? Can somebody look up for me or just, tell me when Maureen Hartnett actually swabbed for dog DNA? Wasn't it something like close to the second trial? So it wasn't even until late 2023 at best, a year and a half later. Former disgraced Trooper Proctor handled the clothing. We have Chaka as our mascot. For those of you old enough to remember, The Land of the Lost was a TV show in the 70s. There's Chaka up there to remind us of where we are. He's our watch animal. He watches over the trial because he knows we're in the land of the lost. Chaka. This is what evil looks like, says Innuendo. We need chakra too.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And
The
would
jury
you
is there.
agree
This is in front of the jury.
that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm.
They're not
I
even
don't
objecting at this point.
believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe
Now they're showing
fell to the
a
ground?
microscope slide of some what appear to be red pieces of taillight, and there are also some hairs. Do you see some hairs in this picture too, or is it just me? See any hairs? He brought up dog hair before, by the way. Wouldn't you expect to see dog hair? It was no dog hair. Nothing was ever checked for dog hair, tested for dog hair. That is the first time again that we're hearing about this in this trial. But do you see what appears to be dog hair in that picture? Not a scientist. I didn't look at that under the microscope, but it looks to me like hairs of some kind. Moving on.
And what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested,
On the
moved or
side of the
slid
road.
on
Now it's on
ground?
the side of the road. Thank you, girl. She's like Texas for gifting 20 memberships. Welcome to the 20 very generously gifted new members. Thank you so much. Now it's on the side of the road. It was 30 feet in. It was 8 feet in. He doesn't know anything about his case. This is a stretch. But again, he should be fully stretched out by now because our credulity has been strained so much during the entirety of this proceeding, persecution. I don't even know what to do with my credulity anymore.
Yes, it did.
And it's your opinion,
I got to hear what she just answered. Hold on.
Feet, I believe.
you think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's
Moved
your
or slid on the
opinion
ground?
that
What does she know?
fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
Movement of
Wasn't
the
asking about
body.
Collision, I was asking about
Somebody moved
his
it.
body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again.
She answered
Are
it.
you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
These little tiny
Correct.
fragments? She said yes. They did not cause the abrasions to his arm.
I have no further questions.
Okay, let's go redirect.
Thank you, Your Honor.
Okay.
What did he just say? He needs to speak to Mr. Woke, who is their intern who is doing the job of the Craig Bates, man of the tiny desk from season 1, has been replaced, trained by Craig Bates, but is now running the tech for the defense team as a volunteer.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Take it down for a second before I make sure what it is.
Dr.
Not a dead body.
Russell, I have up this exhibit. And with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolf,
That's when it was collected, allegedly from the clothing, June 29th of 2023. Almost 18 months later.
you could go back, can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red colored pieces of debris.
Come to your
Thank
screen
you.
for a
And-
second. Look how one of them is perfectly shaped like a canine tooth from a dog. Coincidentally. Well, a couple of them are actually, if you look at them. The two at the top look like little dog teeth. They could be little dog teeth. This big red one looks like it could be the shape of a dog tooth. And isn't that cute how they did that? Interesting.
Do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolf, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolf, now go to Exhibit 1.
I'm taking this off. I think it's an arm picture. We'll see.
Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16th inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only were they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
Really?
Ask it differently, Mr. Wilson.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
What's your
I'm
objection?
going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those, and you are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties
So
of
if we
the
could just
authors.
I'm sorry to interrupt you, Dr. Russo.
I'm
You
sorry.
finished?
The specialties of the authors, yes.
We could take that down for a moment. Your Honor, may I approach, please?
Okay,
If I could have, Your Honor, from Madam Court Reporter, exhibits marked for identification PPP and QQQ.
all right.
And I'll start with PPP if I could, please.
PPP.
Thank you, Madam Court Reporter. May I present PPP to the, thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. Demunick?
Yes,
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? You recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
yes,
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla. And that means upper, lower and upper. Maxillar is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then it goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue.
Mm-hmm.
Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case.
Thank you, Midnight
The
Mike.
puncture wound,
Thank you.
a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
I didn't know Brennan's wife is a legal analyst for CBS. I didn't know anything about that. Can't confirm or deny.
And please request exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. And they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances, slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the morphology of dog bite injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat
Listen,
that?
In practice,
it's a brilliant
It is
way.
hard-
It's a brilliant way to get the witness to read peer-reviewed studies on dog bites into evidence. I'm sorry, I didn't hear you. Could you read that again? He obviously wants emphasis on this sentence. Let's hear it again.
uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is
There it
that
is.
sentence relevant at all to what you've referenced as an incomplete bite?
Yes,
How is it relevant?
because if not all the teeth impact, then you get a partial bite. you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes.
Hmm.
Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting, curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Will, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items, if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay, so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any, is textiles mean clothing?
Yes, and I thought
Was
you
the
meant in this
decedent-
article, but yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt
Please
or
continue.
sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
A lot of this article is relevant, and I don't know if you want to keep.
I don't want
to keep
to
on reading.
keep reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this.
Everyone smash the like
there's
button,
one
please.
section that said,
Thank you.
oh, yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell.
Mhm.
Thank you, Madam Court Reporter. So do those studies, the Demunic and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
So as to the form, Mr. Leslie.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did
Heidi.
those studies look so?
Heidi wants to know if Hank treated the witness this poorly in season 1. Hank was not involved in season 1. It was Adam Lally, and we thought he was bad, but he's nothing compared to Brennan. Adam Lally would be a breath of fresh air at this point.
Solely at individual wounds, or did those studies methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds. How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypotheses was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or?
Well, I'd like to
pain?
give you an example of what you used here in this case, is the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong. And so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression, but I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay?
Yeah. Brennan used all those clips and is trying to use her confessions against her, her alleged confessions. He opened the door to this and let her talk about self-blame. Just want to make sure she okay, we're still at sidebar. They didn't send the jury to lunch yet. Rejected juror, thank you so much for your 20. Says this is the best place to watch the trial. Having total knee replacement on the 5th, and I'm counting on your channel to get me through recovery. Best healing vibes for your surgery, and we will be here. I imagine today's only June 3rd, and this is going to go on for a couple more weeks, I'm pretty sure. Brittany, sure. She could have come back with a mistrial without prejudice. I don't know if the defense would have wanted that, because that would mean that they would have to try the case all over again, Michelle, but that is a great question. Bruni Saint wanted to know if a mistrial would save her from further disgrace. Don't know what you mean by that, but it would have dismissed the entire case, and with prejudice means that they would not be able to try Karen again, because, you know, there are such things as such double jeopardy. But we know, if you've been here for a while, that Massachusetts is where your constitutional rights go to die, and that you know, double jeopardy is not really a thing there. We've seen it. We've lived it. It's outrageous. If everybody could smash the like button while we're here, that would be really amazing. Thank you, Linda, for your Venmo. Stephen, thank you. Kathleen, thank you very much. Zargo says, oh, he says, I'm doing a fantastic job helping us all cope. I mean, that's what we do here, right? Thank you. Sent a couple of messages. Jean says, I believe Chloe is over the Rainbow Bridge, not Cora in New Hampshire. My head in Chaka's Lexus spaceship. Free Karen Reed today. Thank you, Jean. Unfortunately, I don't think we're going to see that today. Sharon, thank you for your compliment. I appreciate you so much, Linda. Thank you for your compliments. You guys are very complimentary in general. I appreciate each and every one of you who chooses to spend your entire day with me. And they're still at sidebar. Thank you very much, Susan, for pointing out the former bachelor Sean Lowe and his dog attack. So many people sent me those photos and I just can't unsee them. So I do not want to look at them or read them again. We have some new filings, and the new filing that we talked about yesterday asking for the missing witness charge was actually exactly what I thought it was. However, the defense is asking for a missing witness charge, not just on Michael Proctor, but also on Brian Higgins and Brian Albert, saying that all three of them are available. They could have called them. They chose not to call them, and that they should be entitled to a missing witness charge on all three of those witnesses that the Commonwealth chose not to call on their case in chief. I don't know if we're going to have time to go through the actual papers today, but I wanted to let you know that I do have them. And that is exactly what I said yesterday that I thought it might be. Thank you, Barbara, for appreciating me. I appreciate you even more. Arnhem said nearly 23,000 viewers on this stream alone just saw this prosecutorial misconduct. How many total YouTube viewers? Free Karen Reed now, justice for John O'Keefe. What a day so far. What a day. My head is literally spinning. The Alessinator said, listening to Brennan is worse than nails on a chalkboard. He's a malicious conflator of confusion. He purposely twists and turns rubbish into blatant lies to confuse. We love you, Melanie, with all of us. I've run out of words, I really think, at this point, for what is going on here. I'm rarely speechless, but every now and again, you just got to step away and you got to look at it for what it is. And we know what it is. We have a Karen Reed trial mixtape on Spotify, and it is below in the show notes. And Land of Confusion, 2 versions of Land of Confusion, the one by Genesis and the one by Disturbed, are both on the playlist. And we ain't got no quit, so we're still here. Look at Melanie Little's left swipe in StreamYard. Changed her name to Melanie Little's middle finger for getting cops who look the other way. Thank you. Sidebar Chick says, so Commonwealth's theory, microscopic pieces can cause tears in skin, yet not one found embedded in the flesh. No. Nope. And no wounds were even swabbed for DNA. Joe says, hey, Melanie, it's my mom's birthday. I would appreciate a shout out to Debbie and Rentham. Hey, Debbie and Rentham, happy birthday from your son, Joe. Your son's got really good taste about where to wash his straw covers, and so do you. Thank you. No, you're the best. Also, thank you. Special shout out to Lou's son, Blake, who is turning 20 today. And her grandson, Archie, is turning 1 today. So happy birthday, Archie. Happy birthday, Blake. Thank you, Lou. She's got great taste too. Your mom and your grandma. She's an amazing woman. Happy birthday, everyone.
May I have a moment, Your Honor?
Yes.
Thank you. You recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case. Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation, what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case.
Nope.
Of the
Wait, unless it's
Lexus
blue arm.
and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his.
Thank you, Will Wallace. It says, even though Judge Canoni mistakenly did not grant the mistrial with prejudice, this witness is still damaging to the Commonwealth's case. No nonsense, all common sense, and she reeks of she knows what she's talking about. She's doing great. Thank you, Will.
That would be
B20.
toward the back of that slide presentation, probably around 130-ish.
Thank you, Plant Lady. Everyone smash the like button. We promise the Canton
That's it.
PD
Yes. And what slide number is that?
will not get your DNA.
109. So,
And even if they did, they wouldn't know what to do with it.
Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in a reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect
Thank you.
at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer.
Get here.
Right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? Lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with
Indicating the bones from wrist to elbow.
Of the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here, what is the likelihood of there being any fracture to any bone?
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe that there is a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe,
Yes,
and you've reviewed the file, the medical records files, correct?
yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
No bruising.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scorbello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scorbello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
She opened up the legs. We didn't know she opened up the legs. Didn't?
May we approach her for lunch?
All right, jurors, I'm going to send you out for lunch.
Yeah, I mean, it's 1 o'clock.
Yes, come on up.
She opened up the legs. Okay. Because we heard, didn't Welcher say that that there were no x-rays taken at some point? Right. She opened up the legs. So now the doctor is going to be able to testify that there were no fractures in the legs, no bruising. She would have seen this, that, and the other if this man had been hit as a pedestrian, and this is fantastic and I'm here for it. Right. Are the wounds consistent with a fight? Oh, snap. She opened up the legs means she examined the bones in the legs. We've never seen the autopsy report, so we don't know unless it's testified to. Name rhymes with Mariner. Okay. Ariner. Ariner. Did I get it? Ariner. I had to do 20 super chat because the orange shows so well with your blast. Oh, thanks. Thanks for your amazing coverage and community that we don't get anywhere else. Oh, thank you. Right. Wait, so there's just a little short break while the jury exits. Okay. So they're coming back now. Thank you. Ariner. I think I got it. By George, I think she's got it. And Anne-Marie had a funny super chat here that said, I think Bev should ask for her job back at the Lemon Tree. Fun fact, I did work at the Lemon Tree when I was in high school, sweeping up the hair and washing hair. That's hilarious that you should even bring up is the Lemon Tree still a thing? Does it still exist? Thank you, Living That GP Life Sloth Style, for your very nice compliment. There's nowhere else I'd rather be watching this clown show than with you and the other cupcakes. Love you with all of my heart too. No, I can't get the autopsy report. It's sealed. Cannot get it. By George, I think she's got it. I'm going to have to jump off during lunch if they don't come back, but because I have another meeting I have to jump on at 1:15, but I'm going to play some Duty Ron for you. So tell me what you want to watch. Do you want to watch, because I talked to Duty Ron this morning, and of course he said you can play any of my content anytime. Do you want to watch Ed Wallace going off last night on Kelly Dever, or do you want to watch a video on Dr. Welcher? That one's about 20 minutes. Let me take a look and see if, I mean, last night he was on fire when they were talking about Kelly Dever, and very interesting insights on that. Okay. I think majority will rule here. I don't know if she's going to get back on the thing, but somebody said, let's look at Jess Machado's tweets. So let me just take a look and see what she said throughout the morning, and if I can just glean any sort of juror reactions from this. If you choose to wait on the cesspool of Twitter, her Twitter is Jess Machado Show, at Jess Machado Show, and she is sitting in the courtroom. I think that is her all the way on the right side of the high top behind the O'Keefe family and friends. She just noticed that one of the jurors, she nicknames them because she can't really describe them. The one that she has nicknamed Jenner has 2 notebooks. That's interesting. And then when 3 hours ago, she said, Dr. Russell was just asserting that there are not published standards on many different things, and the whole jury had their heads turned toward her. She's doing it again, and everyone is looking. Some jurors are even leaning in to look at her. The man sitting in the seats next to Paul O'Keefe is laughing and shaking his head at her testimony. She says, my own personal take is that Brennan is doing a great job of attempting to dismantle Dr. Russell's previous testimony. This skill set is simply something that Lally does not possess. The only problem is that I'm not seeing reactions from the jury to this exchange between Brennan and Russell. There has not been many notes being taken aside from note taker, which I guess is her nickname for another juror. Brennan continues to go back, this is 3 hours ago, to Dr. Russell's previous testimony, and one of the jurors inhaled with raised shoulders, blew out in frustration. Brennan just said that Russell never said canines, not teeth, and Russell said it doesn't matter, they are the same thing, and a juror laughed, and a smirky juror smirked. Brennan just repeated a question, and a juror who normally doesn't react seemed to exhale and then leaned forward and then slumped back in her seat. Moving on. Whenever I think this was the sidebar before the mistrial was asked for. It said this sidebar is aggressive. I can hear much of what is being said, which I will not be reporting because she's sitting in that seat closest to where the sidebar is. And then we heard during that sidebar, she says, let's check in on the jurors. 1 is yawning. 2 is looking down, sitting on hands. 3, writing notes. 4, looking at the Reed family. 5, looking at sidebar. 6, looking around the room. 7, scratching head. 8, leaning on hands. 9, standing. 10, sick. 11, looking down. 12, arms crossed, looking at sidebar. 13, looking at me. 14, looking at sidebar. 15, looking down at notebooks. 16, looking at the fan. 17, looking towards the O'Keefe family. 18, looking at the sidebar. And then, I believe, that was when the mistrial motion happened. Okay, they're coming back to the table. Let's see if there's anything.
All right, Chrissy, does that help?
Good, all right.
All right, they're going to be on break until 2. And so I'm going to entertain you with last night's live stream or part of it anyway, from my friends, Duty Ron and Ed Wallace. Fun fact, before I started my own YouTube channel, I was a guest host with Duty Ron for many, many episodes, like so many I can't even count, probably 50, with Duty Ron, because Ed Wallace was away and he was on assignment at an undisclosed location. And so I filled in, and he is a big part of the reason why I am here today. And so I love both of these men with all of my heart. And I'm going to let you listen to last night's live stream while I take a break. And if you need to take a break, please do. I'm going to put up the banner that jury's out to lunch until 2 p.m. And if you would, please go over and give Duty Ron and Ed Wallace a like and a subscribe. And these two guys are retired NYPD detectives. He will give you a little spiel if you're not familiar with them. We have a lot of crossover viewers. So let me just, what is the name of the channel? The actual name of the channel is @DutyRon. Okay.
Of Crime Time with Duty Ron and Ed Wallace. We are retired.
Let me just put @DutyRon in my banner. Hang on one second. There may be a language warning. I'm not sure. I did watch part of this last night, but not the entire thing. So just guide your actions accordingly. I will see you guys in a little bit. I have to jump and do a few things offline, and I will see you real soon. Let me full screen this. Put the captions for you. Enjoy.
Good evening, friends, and welcome to another edition of Crime Time with Duty Ron and Ed Wallace. We are retired New York City police detectives and 9/11 World Trade Center first responders. If you like all things true crime related from the police detective's perspective, hit that subscribe button, hit that notification bell, so you get all things Duty Ron and my partner in crime right here, Ed Wallace, when we go live or upload another video. And as you know, tonight, day 25, unbelievable testimony from Boston police officer Kelly Dever. If it wasn't bad enough with the trustworthiness of the police in this case, it just took it down 100 notches. Ed, your thoughts on what we heard today? And don't forget, we also had great testimony from Dr. Russell, but your thoughts on Kelly Dever?
My head exploded today with her. I mean, my bullshit meter was going off left and right. My hairs were standing up on end, and I couldn't believe, her testimony. And, she doesn't know it. There's a big point towards the end of her testimony where she says that her career depends on this testimony. But guess what? Her career is done. She just doesn't know it. Yeah. Okay. You can't have a cop who has this kind of memory problem.
Yeah.
Okay. So either she's got a memory problem, which maybe a medical condition, maybe a neurological condition, or maybe a psychological condition. She's incompetent, or she's a liar. Okay. You choose. Or she could be some combination of the three. All right. There's no doubt in my mind what transpired here. Okay. She saw something.
Yeah.
She saw something and she reported it to the feds. Okay. There's no such thing as a false memory. Okay. And she saw something on that monitor, whether it was at the time that it occurred or a video of it later. Yeah. She saw it. She said something. And I believe, in my heart of hearts and my police sense tingling, somebody got to her, and this is what's happening.
Listen, she's a 2-year wonder. She's a rookie as far as we're concerned, as far as any seasoned veteran's concerned. And in my opinion, Kelly Dever claims that she had distorted memory. And when you hit the nail right on the head, Ed, she either saw something after the fact by watching a video from the Sally Port, and then obviously the FBI comes in August 9th of 2023. That's some 18 months later, Ed and audience. 18 months later, she tells them that she saw Brian Higgins and the Berkowitz,
Chief
the
Berkowitz.
Chief Berkowitz go into the Sally Port, and I wrote this down for, what did she say? Where is it? She saw Brian Higgins and the chief in the Sally Port for an uncomfortable period of time. And now wildly long period of time. Yeah, I have so many notes here. It's like going through it. But she was interviewed on 8/9 of 23 by the FBI. And then all of a sudden, magically, the chief of police, the chief calls her into his office.
Commissioner.
How often is the commissioner calling people? And you and I had a discussion. I've seen the commissioner 2 times, a couple times in my career. Once is when I retired, another time at a function, and I was introduced to him by a family member, police commissioner at NYPD. You told me a half a dozen times or so for different incidents.
Most of my stuff was for briefings on high profile cases, the 93 World Trade Center attack, the 9/11 attack. I lifted a fingerprint off a human skin, and it was the first time that occurred, and I had to go up and demonstrate it to the police commissioner. Yeah. Okay.
But on a 2-year wonder in to say, good job, you did a great job.
Yeah.
Boston Police Commissioner Michael Cox calls her into her office, and then all of a sudden, she gets amnesia, convenient amnesia, and she distracts her. Yeah, she detracts her statement. She says that she made it right.
A year ago, she told the defense team over the phone that he said 2 things to her. Right, we're going to support you no matter what your testimony is, and do the right thing.
Yeah.
How is that not tampering with a witness? I mean, I'm no lawyer, right? But, seeing all the bullshit that's occurred to other people they've arrested in this case for quote unquote tampering with witnesses. How is that not tampering with the witnesses? Your boss calls you in, okay, and sits you down. And that's all. He only had 2 things to say. Hey, we support you no matter what your testimony is. That's what he said. No matter what your testimony is, and do the right thing. And then she has amnesia about that. Let me tell you something. She says she testified in 12 cases. I find that highly unlikely in that short period of time. Maybe she's combining what she did in Canton PD and Boston PD. But if you were a defense attorney in those cases, pull your case, put in a review of the case, and bring it back in and see if she had foggy memory for what she testified to in those cases.
Yeah.
She's done. She's done as a cop. In any normal law enforcement jurisdiction, she would be done. Nobody would want her to testify in a case.
Absolutely. And Natasha Richardson's from the chat. Thank you for being here. Thank you for being a channel member. She said, Ed, did you just curse? Ed's been cursing quite a bit.
Did I curse? I don't know. Did I curse?
She might have. I'm not sure. Maybe you did. But maybe you didn't.
I can't. My memory's gone. I can't remember.
Did you see the police commissioner? Another thing too, I was trying to say before, but is she, to add insult to injury, accused Alan Jackson and the team. She didn't actually say himself, but he was the one who was. It
was 2 males. She said a male defense lawyer,
but she never said his name. But she accused the Karen Reed defense team of threatening her arrest. Let's listen to this small piece, and we'll be right back with you guys. Thank you all for being here, and thanks for the support.
Serious claims about the defense brought to light during testimony from their own witness.
They said that they would charge me with perjury.
What else was said on the stand that's also under scrutiny?
Those wounds were inflicted as a result of a dog attack.
The dog bite expert from Reed's first trial returns to the stand.
These are not my words. I'm not really comfortable reading these. Do I have to say these words out loud?
Michael Proctor's infamous texts read aloud, but not by the former state police investigator. We take a closer look with our panel of experts. Canton Confidential, the Karen Reed murder trial, starts right now.
In what could arguably be described as the most heated testimony of the defense's case so far, Kelly Dever, a former Canton police officer and now Boston police officer, took the stand. Good evening, I'm Glenn Jones. JC has the night off. She was working the morning of John O'Keefe's death when his body was found. She was pulled from the field to cover dispatch, but what she saw or didn't see on a security camera led to fireworks in the courtroom. Our Melody Mendez will bring us up to speed on today's memorable testimony. Mel, Officer Dever's testimony was just fascinating to watch.
It really was, Glenn. Here's the thing. You know, we know that she was in the dispatch center, as you mentioned. That's essentially the hub for dispatch in a police department. There are phones, there are monitors, which show surveillance cameras and the video from different parts of the department. So Alan Jackson began with what seemed like pretty basic questioning about the monitors and what they would show. But immediately Devers pushed back and seemed resistant, said she couldn't recall, and things very quickly got heated. Take a look.
You won't be here today now.
Officer Kelly Dever immediately resistant to answering questions from the defense, often with long silences like this one.
I don't know why I'm here. I have no connection to this case.
At a few points, the judge stepping in.
I don't know what that means. So what do you mean you're going to go with yes? Is your answer yes?
I'm going to pause this just for a second because I was trying to type something, but my keyboard's malfunctioning. If you felt that the testimony by Police Officer Kelly Dever of the Boston PD was honest and trustworthy, was she being forthright with the defense and prosecutor? Press a 1 if you thought she was being honest today. Press a 2 if you didn't feel she was being honest. I'm already registering my number 2 right now. But did anybody at this point think that she was going to start crying? Ed, I thought she was definitely going to cry here.
At this point, there's no reason for any of this, and her deflecting and obfuscating and not wanting to answer the question. She knows the answer, and she's lying. She won't give the. Listen, you can lie by omission. You don't have to. You know, you can. There's many ways to lie. All right. So she knows the truth. And she won't give him the truth. All right. She told the FBI. And by the way, that's another thing. But Judge Bev never wanted the FBI mentioned, right? And she doesn't want anybody to mention it. They said agent. Also, she didn't want ever mentioned the first trial. Well, this witness mentioned the previous trial multiple times. So that door's being kicked wide open. Then this witness right here, mentions the FBI. So that door's now been kicked open. A witness kicked open that door. Okay?
And there was nothing to stop her. That's the messed up part, is that Judge Bev heard it over and over and over again. Previous trial. And then that famous FBI, almost like that was like, you know.
There's no way as a cop that she should be intimidated by a defense attorney saying, they're going to lock her up for perjury, because I don't believe that ever happened, first of all, right? And as a cop, you should know that a defense attorney can't lock you up for perjury. They can say, if you don't testify honestly, there could be perjury charges here, okay? Right. They could say something like that, and there's no doubt in my mind that's probably what they said, okay? That, you know, if you don't testify, truthfully, there could be perjury, okay? Yeah. Now, saying that they're going to lock her up, she knows as a cop that's bullshit. They can't lock her up. They can't charge her. Only the police and can arrest you, or the DA's office can arrest you, and only the DA's office can charge you. Okay.
Stupid. She made like she didn't know.
Please. Yeah. If she thinks she's going to go back to patrol now and everything is going to be honky dory, she is sadly mistaken and delusional.
Yeah.
She's going to be riding a desk. Because, again, she can't be out there making collars. She can't be out there investigating anything. No district attorney is going to want to touch her to testify after this performance.
Yeah. Let's listen to the rest of this.
It was not a memory it was a distorted memory. Therefore, I can't state it, because at this point it would be a lie. Like, you can't remember my name. I don't remember.
Today, Dever claims the defense tried to get her.
That was another thing. Come on with that. I mean, that
doesn't make her look good.
Yeah, it was a bad look. And Alan Jackson came right back at her. But this is just a small piece. We have a bunch more to show you guys. Let me just finish this, and then we'll come right back to this. But again, look, we have amazing sergeants in the chat. welcome, Amazing Ants. Good to see you back. Interesting testimony here today. When you look at this and you look at the big picture here, everything that she did here was wrong. And I heard several news outlets say that this hurt the defense. How in God's name are you seeing this as her hurting the defense? People see things through different lenses, Ed. It's unbelievable that I don't know if anybody else heard anybody report on this. I'm not talking about YouTube channels. I'm talking about the mainstream media. And I was just like, what?
I get this all the time. I sit in cases and I'm watching the trials and I'm listening to the media afterwards, and I say, it's just their bias that they're reporting. They're not reporting the truth. It's their bias, okay? Because that statement by the media about hurting, and that was ABC News tonight, that they hurt the defense and this witness blew up in the defense face. Yeah, the witness blew up. Yeah, she detonated herself like a suicide bomber. Excuse my reference there. But this was totally self-inflicted. Okay.
Yeah.
This, and it didn't get on the defense. She can make all that accusations about the defense threatened her to lock her up. And who's buying that except for those that want to buy it, the biased?
Yeah, lots of the mainstream media is biased, and they are not looking at this thing and able to report the way we're reporting here. There's nobody, holding us back from our opinions. And look, coming from 2 seasoned NYPD detectives, it was clear and apparent what she was doing here, and she was covering the ass of those two officers that she mentioned. Brian Higgins, who's alleged by the defense to be the main culprit in the demise of John O'Keefe, police officer John O'Keefe, and also Chief Berkowitz. So let's listen to the rest of this, because a former Massachusetts state trooper gives a little commentary on her testimony today, and it was interesting to hear it. I don't know if you caught it, Ed, but it's coming up right after this.
It was not a memory it was a distorted memory. Therefore, I can't state it because at this point it would be a lie. Like, you can't remember my name. I don't remember.
Today, Dever claims the defense tried to get her to lie on the stand.
They were looking for me to say that I saw Higgins and Berkowitz in the garage with the car.
Did you share with them that wasn't an accurate memory?
Yes.
How did they respond?
They became very aggressive, raised their voices, and the one word that I can very definitely remember is they said that they would charge me with perjury.
A claim Jackson refuted.
Did you also say on that phone call, I know you're going to tear me a new one because I'm changing my testimony?
Changing, no, but you're trying to do that.
Alan Jackson pressed her about being called into the Boston Police Commissioner's office about this case, following it up with this question.
Have you ever heard of something called the blue wall of silence? Objection.
Sustained.
Do you think it's important for police officers to protect one another in the field and out? Objection.
Quickly, I want to answer this question. Somebody in chat, DH, says the lawyer, that's Peter Tragos, friend of Crime Time with Duty Ron and Ed. I've had him on as a guest. He said, according to DH, that she wasn't a good witness to the defense. But again, this person disagrees. I would be open to hear any reason that anybody has that she was not good. She, if anything, that the jury that were watching her testimony, she was borderline a hostile witness, borderline. She was obnoxious. She was rude. She was acting like a schoolgirl, like somebody who was having a fight with another person in high school. So not professional, and showing the bias and showing that blue wall of silence. I mean, it is so clear and so evident with her testimony that she flipped that script because she was called in to the police commissioner's office and told, if you don't withdraw this and retract it, your career is going to be a tough one. They're not going to say, I'm firing you, because they can't, but she will be walking a beat on the Brighton Beach boardwalk for the rest of her career.
I think there was some opportunities that were missed here, like questioning him, why did you leave the Canton Police Department? Okay. I think there were other questions that could have been asked. She called the hypothesis of John being beaten in the Albert's house and dumped out on the lawn a conspiracy theory. Okay. How do you call it a conspiracy theory if it was never really investigated?
And Ed, she admitted to watching the trial, but she brushed it off like, oh, it's 6 hours a day. I don't have time for that because I work, during the day. Did you catch that? She was further rubbing in, like she was being questioned and asked if she's watched the trial, if she knows what's going on. And she was like, oh, I watch here and there, but I don't have 6 hours to watch. It's, it goes on all day long.
Where's all this missing video? Aren't there a lot of missing videos from the Sally Port?
Oh, yeah.
Okay. Where is it?
Definitely remember is they said that they would charge me with perjury.
A claim Jackson refuted.
Did you also say on that phone call, I know you're going to tear me a new one because I'm changing my testimony?
Changing, no, but you're trying to do that.
Alan Jackson pressed her about being called into the Boston Police Commissioner's office about this case, following it up with this question.
Have you ever heard of something called the blue wall of silence? Objection.
Sustained.
Do you think it's important for police officers to protect one another in the field and out? Objection.
Sustained.
Karen Reed speaking to that outside of court.
Are you suggesting that Deborah may have been coaxed into changing her testimony?
Yes. What's your reaction to her demeanor? I didn't suggest it. She did. When she was called into the commissioner's office, the story completely changed. We subpoenaed her to testify to what she told other authorities and just wanted her to be as honest with us as she was with them.
Honesty, what the defense says they're looking for, and what Deborah says she's giving.
My entire job revolves around what I say on the stand right now. If I was to lie, I lose my job.
There you have it right there.
Anytime you testify, if you're to lie, you lose your job. Okay?
Exactly.
Tell me something we don't know as cops.
Yeah. I mean, that's as clear as day. Everybody knows it. Karen Neth, thank you for being a member. And she says, take her badge away now. Way too immature. Listen, she is a Canton High School graduate. She was born and raised, or a good part of her childhood and growing up. She is a Cantonite 101. She's been in Canton for a great part of her life. And she showed it. She showed her true colors here today, and it was a very bad look, ladies and gentlemen.
Honesty, what the defense says they're looking for, and what Deborah says she's giving.
My entire job revolves around what I say on the stand right now. If I was to lie, I lose my job. I lose everything.
If you agreed with what you said in August 2023 on this witness stand, you would be implicating two officers, fellow officers, as having been in the Sally Port weirdly for a wildly long time with the SUV, implicating not one, but two fellow officers, correct?
If I was to lie, then yes.
Stop it there.
Yeah, and here, I want to just highlight this comment, and Ed, hold that thought. Greg sends in a $5 and said it wasn't good for the defense because some people, it wasn't good for the defense because some people will believe a cop no matter what. It takes one juror that hates defense lawyers to believe her. But guess what? This jury is a younger, they're made up of younger folks than the first trial. If they've been paying attention from the day one, this is week 7, folks. If they're paying attention from day one, they're not just seeing this here today. This is day after day after day with witnesses that are being less than honest, that are coming up with changed stories. Ed, go ahead with your thought.
This just plays into the totality of all that the defense has been saying in all of their cross-examinations during the prosecution cases. The sloppy police work, 0 to none chain of custody, the improper protocols for forensic evidence, the improper handling of the evidence, improper handling of witnesses, not interviewing people for years later, not doing reports for years later. This all missing videos, this all falls in. I mean, if you look at the totality of all of what transpired here, okay, and then having seen what these same players have done in other investigations, then you got to ask yourself, why did they deviate so much in this investigation? Okay, and you know, I mean, it doesn't take a rocket scientist, okay, you know, or a bogus engineer dances with dummies, okay, to figure this out. Okay, I mean, it's plain as the nose on my face, and believe me, it's a big nose. Okay, they know the jurors sitting there, and you know, you don't have to be a cop hater, or you don't have to be a cop lover to look at this and say, yeah, something's rotten here in Canton.
Mm-hmm. Amen.
All right,
brother.
testimony resumes tomorrow at 9 a.m. here in Dedham. Glenn, back to you.
Melody Mendez at the courthouse. Thank you. Today's testimony from Officer Dever was compelling in so many ways, and joining us to talk about it now is retired state police trooper turned security expert Todd McGee. Todd, I'm so grateful you are available on short notice, because this dramatic clash between Dever, a defense witness, and defense attorney Alan Jackson really caught everyone's attention today. Should we expect that all police officers receive some kind of training for testifying at trial? And did it surprise you to hear that as a rookie cop ahead of testimony, she got time with the police commissioner, Michael Cox?
Well, good evening, Glenn. Thanks for having me. Yes, police officers do go through courtroom procedure training and the understanding of how to conduct yourself in a court of law and all of those sorts of things, as you might understand. What was interesting about her testimony today, she was obviously nervous about this perjury issue that came up in the prior testimony and an interview with the federal agents. So, you know, then what came up in the trial regarding the interview with Superintendent Cox was where the defense really tried to pinpoint where her testimony may have changed. So interesting to see the dynamics in the courtroom, very heated exchange at times. But again, this is, again, not unlike we've seen from other witnesses.
When Officer Dever said her livelihood is dependent on her testimony, some interpret that as picking no sides and siding only with the truth, but others see it as code for the blue wall of silence. How did you hear it when she said that?
I saw that as her trying to actually protect herself in that response. So, you know, an average police officer is going to say, yes, we should protect other police officers in the field. That's what we do. That's why we call backup. Now, the context is in the form of the blue wall of silence. So in that challenge, she paused, hesitated, and thought well and deep about what her response was going to be.
Yeah, so the question now is whether or not that's seen as credible by the jury. Todd McGee, thank you so much.
So, Ed, I wanted to say this, you know, look, the FBI didn't just go to BPD and say, we want to interview Kelly Dever. They went and they did what they do. They interview everybody that's possible, or anybody that they feel has had contact on that night with anything inside that precinct. So she's not the only one that they interviewed.
Right.
And
well, that's what I was saying. How did they target her? How did they come to her you know, so many years later, right? Because she was working that night in the dispatcher's office when Higgins came in. Okay.
She was also not the only one working, because she described getting that phone call from the lieutenant and he told her, hey, go back in, relieve this guy on the 911 board. You stay for overtime. So she wasn't the only person. That's a 30+ man department and a nor'easter. So you know that they were holding people over and people were working.
She
So
was held over. She did overtime, and then she said her overtime ended at 15:45, like 3:45.
35.
Okay. But did she actually leave? She said in the testimony she left. Did she actually? Did anybody investigate whether she hung around or? Maybe she was so tired she took a nap at the precinct because apparently they're known to do that there. Okay.
I brought that up, Ed, is because people might looking at this thing might be saying, well, the FBI went just after her. No, they interviewed multiple people and everybody that was on duty and active during a certain time frame. And I don't know how far back they would go, but it would probably be the beginning of that midnight tour going straight into the next day. So multiple lieutenants, supervisors, and so forth were interviewed by the FBI, probably got nothing from them. She's a rookie. She thought that she wanted to be, helpful and at that time and truthful. And she told them, because again, it was 18 months later, she told them what she perceived that she saw. And
on the monitor. She said it wasn't if she was physically in the Sally Port when they were there. She was watching from the dispatcher's desk on the monitor. And that's another thing. She was fighting with Jackson about the monitors for the cameras and the cameras. I mean, these are silly things. Why? And this is why you can't trust anything she says. There's no reason to nitpick all these little details when listen, if Alan is asking you, he already knows the truth, right? When any a good defense attorney or prosecutor asks you a question, they already know the answer.
Of course. Yeah.
Okay. So, I mean, why argue and why obfuscate and why deflect and why all this anger and so forth? You put yourself there. You said something to the feds. The feds turned it over to the defense team, and then you wondering why you're on the stand.
Yeah, just a lot of hogwash. And again, like I said, if anybody was not feeling good about the police, this is more reason to not feel any better about them. I want to play just a short period. It's just a small piece of this. This is when she first took the stand with Alan Jackson coming at her with questioning. It just started slow, but then it built. So let's.
Okay, I'm gonna stop that here because I want to read to you the new filings, but I hope you enjoyed that. And if you would like to go watch the rest of that later, you know where to find it. That is Duty Ron and Ed Wallace's show from last night on their recap on day 25. And love those guys. With all of my heart. What'd you think? If you're new to their channel, what did you think? Don't you think they're great? Okay, let us take a look. We're going to look at two new filings. We've got the motion to reconsider Michael Easter, and we also have the motion for the missing witness charge. Let me take a look. See where I put them. Is there a troll in here that did not get taken care of? Wow, did Sydney make a racial comment? Was that a racial comment about Todd McGee? I'm a little confused about that. A little confused about that. We don't tolerate that here. Sorry, we don't. Maybe that's acceptable in other places, but not here. I hope I'm wrong about that. Hope that's not what you did, but you never know with people. You just never know. All right. Let's start with 707. 707, which is the defendant's motion to present a missing witness argument. And this one is redacted because portions of it are impounded. And it is 8 pages. Let's take a look. Docket number 707. This is docket number 707, and this was filed yesterday morning. It was not scanned into the system yesterday, and so we were not able to look at it yesterday, but we have it today. And so here we go. Need my red pen. And here we go. Defendant's motion to present a missing witness argument and request for subsequent instruction. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to allow for the use of a missing witness argument and subsequent instruction in her defense. All foundational requirements for a missing witness argument and instruction are met. Allowing Ms. Reed to present a missing witness argument would best position the jury to consider all of the evidence at issue, including what is missing from the Commonwealth's case, in their deliberations. Point 1, all foundational requirements for a missing witness argument and instruction are met. It is appropriate for the court to grant a missing or to give a missing witness instruction where a party has knowledge of a person who can be located and brought forward, who is friendly to or at least not hostilely disposed toward the party, and who can be expected to give testimony of distinct importance to the case. The party would naturally offer that person as a witness. If then, without explanation, a party does not call the witness to offer testimony, the jury may infer that a prospective witness would have given testimony unfavorable to that party. The underlying premise of a missing witness instruction is that a party's failure to call a prospective witness raises a reasonable inference that this witness would have provided testimony adverse to that party, and a jury should be afforded the opportunity to consider that information in their deliberations if they deem it to be reasonable. A trial judge has discretion to refuse to give a missing witness instruction requested by either party. However, cases supporting the need for judicial caution in permitting an adverse inference are inopposite when the interference is to run against the Commonwealth, because there are no constitutional concerns to warrant the call for caution in such instances. Notably, the degree of judicial discretion may be lessened when it is the defendant rather than the Commonwealth who seeks approval of a missing witness argument. A. Michael Proctor, Brian Albert, and Brian Higgins are all available and friendly to the Commonwealth. Basic to the inference is the existence of evidence of physical availability of the witnesses and the likelihood that he can be produced by summons or otherwise. Michael Proctor, Brian Albert, and Brian Higgins were all listed on the witness list presented to this court by the Commonwealth. There has been no showing of physical unavailability for any of these three witnesses. Additionally, the defense is informed that Brian Albert and Brian Higgins were both under subpoena by the Commonwealth. Michael Proctor, Brian Albert, and Brian Higgins are all friendly to the Commonwealth. All three witnesses testified cooperatively in the 2024 proceedings as witnesses in the Commonwealth's case. There is no reason to believe that these individuals would not continue to cooperate with the Commonwealth as friendly witnesses less than a year after their prior testimony. Additionally, the fact that Ms. Reed could call these three witnesses does not render the adverse inference impermissible, because the Commonwealth is more acquainted with these witnesses and would naturally be expected to call them in establishing their case in chief. A missing witness instruction may be properly given where the prospective witness is more friendly to one side than the other, even if the witness was available to the party requesting the instruction. So you see here also the risk that you run when you call a witness on your own is like what happened when they called Kelly Dever to the stand. They could not prep her. They did not know what she was going to say. And she did wind up changing her entire testimony, and everything that she told the FBI, she changed on the stand. So just because the defense can call Michael Proctor, Brian Higgins, and Brian Albert doesn't mean that they have to. And they may be entitled to this jury instruction. And we talked about it yesterday, and this is exactly what I thought it was. We did just discuss Proctor yesterday, but they may be entitled to it for all three of these witnesses should they choose not to call them. B. Michael Proctor, Brian Albert, and Brian Higgins each would be expected to give non-cumulative testimony of distinct importance to the case. Each of these three witnesses would offer meaningful testimony that is neither cumulative of other witnesses that have been called, nor would their testimony be unimportant. I'm going to skip some of the case law here so we can get through this before the break is over. Michael Proctor's anticipated testimony would not be duplicative of other witnesses called by the Commonwealth and is central to the case. Testimony from the lead investigator in this case is of great importance to this case, as the role is inherently unique compared to other witnesses, both civilian and law enforcement, put forth by the Commonwealth. Michael Proctor was the lead investigator and was responsible for recovering a significant amount of the evidence in this case. Moreover, Sergeant Buchanan's testimony confirmed that nearly every piece of evidence recovered in connection with this case, including all of the taillight pieces recovered at the scene, Mr. O'Keefe's clothing, Mr. O'Keefe's cell phone, and the surveillance video from the Canton PD, were in Michael Proctor's sole possession for months or years before they were booked into evidence. Similarly, neither Brian Albert nor Brian Higgins' anticipated testimony would be duplicative of other witnesses called by the Commonwealth and are each central to this case. No one, except for Brian Albert or Brian Higgins themselves, can testify to their exact whereabouts within the home at 34 Fairview on January 28th and 29th. Sarah Levinson and Jennifer McCabe's testimony are not sufficient to support the claim that John O'Keefe never entered the curtilage of 34 Fairview, as they were not all together the entire time they were at 34 Fairview, leaving Brian Albert and Brian Higgins each with the opportunity to interact with John O'Keefe within the curtilage of the home without any other witnesses being aware. Specifically, no other witness has testified thus far or even would be able to testify to and be meaningfully cross-examined about the reasons for Brian Higgins visiting the Canton PD around 1:30 a.m. on January 29th of 2022. Additionally, no other witness has testified thus far or even would be able to testify to and be meaningfully cross-examined on or about, cross-examined about, the reasons why Brian Albert, a trained first responder, and his wife did not come outside around 6 a.m. on January 29th of 2022, when their bedroom was mere feet from the scene of drastic life-saving efforts by paramedics and firefighters, response by police officers and their respective cruisers with lights, and the sounds of 3 women discovering a loved one unresponsive in the snow. C. There is no logical or tactical explanation for the failure of the Commonwealth to call Michael Proctor, Brian Albert, or Brian Higgins. If the Commonwealth provides, Your Honor, an explanation for not calling an unavailable witness, and that explanation is sufficient, and that explanation is sufficient, the missing witness instruction can properly be rejected. An explanation is sufficient where the trial judge is satisfied that the circumstances thus offered would, in ordinary logic and experience, furnish a plausible reason for non-production. Here, the Commonwealth has not and cannot provide a sufficient explanation for not calling Michael Proctor, Brian Albert, or Brian Higgins. The Commonwealth understands the risk that the testimony of these 3 witnesses poses for their case, as all 3 are highly susceptible to impeachment on relevant and non-collateral issues. The Commonwealth is consciously choosing to obscure and hide from the jury the complete picture of what occurred at 34 Fairview Road on January 28th and 29th. Conceitedly, witnesses may be withheld because they are susceptible to cross-examine on collateral issues or for other tactical reasons, but that is not the position the Commonwealth is in with these 3 material witnesses. All 3 of these witnesses are susceptible to cross-examination regarding issues that are central to this case. 1, Proctor's handling of the investigation and relationship with the very witnesses who should have been suspects in this case, and subsequent termination from the Massachusetts State Police as a result of his conduct in this case. And 2, prior admissions by Brian Albert and Brian Higgins that they left the rest of the group at 34 Fairview Road for a period of time in the early morning of January 29th, 2022, to look at photographs in some other part of the house. And then they give 1, 2, 3, 4 more reasons that are all redacted for whatever reason. And my gut on that says that maybe these are things that are protected by a federal order and needed to be redacted for public consumption. Point 2. Depriving Ms. Reed of the opportunity to present a missing witness argument and denying giving her the subsequent instruction would undercut her ability to present a defense. There is a critical distinction between argument by counsel, that argument presented by the Commonwealth is insufficient, and a missing witness argument. A defendant has wide latitude in any and every case to argue that the Commonwealth has failed to present sufficient evidence and that there is an absence of proof or that evidence is missing. A missing witness argument is distinctly different from this scenario. While both allow a defendant to argue the Commonwealth did not meet their burden of proof, in the former, the defendant argues that the evidence has been produced. The evidence that has been produced is inadequate, and this can legitimately include pointing out specific witnesses or evidence that have not been produced. However, in order to argue or ask the jury to draw any conclusions as to the substance of the evidence that has not been produced, counsel must first seek judicial consent to present such an argument and have a subsequent instruction follow suit. Hey, Larry. Yeah, Dr. Russell is still on the stand. There was a wild motion for a mistrial, like right before, earlier in the day. If you haven't seen, today's testimony is fiery. Defense moved for a mistrial with prejudice. It was denied, but I thought their grounds for it were good. So if you haven't watched it, Larry Foreman, DUI guy, rewind and go check it out. A significant portion of Ms. Reed's defense has been focused on the inadequacies of the investigation into the death of John O'Keefe and a lack of consideration of other suspects. A judge is required not to take the issue of adequacy of the police investigation away from the jury. Not affording Ms. Reed the opportunity to argue that the jury should draw adverse inferences from missing witnesses in the Commonwealth case that are deeply involved in the investigation itself will erroneously remove from the jury's consideration the precise issues sought to be raised by the defendant. This jury should be provided with the necessary framework for considering the absence of evidence or witnesses, should they deem it relevant information to their deliberations, and assess the weight and significance of the missing evidence or witness in relation to the evidence presented against the defendant. Conclusion, for the foregoing reasons, Ms. Reed respectfully requests that this honorable court allow her to present a missing witness argument and grant the subsequent instruction. XOXO. Ellen Jackson, Elizabeth Little, David Yannetti, and Robert Alessi. The pro bono team extraordinaire. And so, as I explained to you yesterday, a missing witness charge did not mean that the witness cannot be located. It means that the witness is available. The Commonwealth chose not to chose not to call them in their case in chief, and allows the jury, because in Massachusetts you have to allow the judge has to give you permission to argue it, allows the attorneys to argue in closing that the jury may draw an adverse inference from the fact that the Commonwealth chose not to call Michael Proctor, Brian Higgins, and Brian Albert because they knew it would be bad for their case, because for whatever reasons they are impeachable, or whatever testimony they would give would not be favorable to the Commonwealth or their case, and that's why they chose not to call them. Let's see, moving on to docket number 708. This is the motion for reconsideration of expert witness Michael Easter, and I've been screaming, I hope they make this motion for a long time, and I feel heard and seen and validated, despite the fact that it had nothing to do with me. It makes me feel heard. This is docket number 708. Docket number 708. The court is still on lunch. The jury is still out. Don't worry, you're not going to miss a thing. This was again filed yesterday morning, and this is defendant's motion for reconsideration of the court's March 31, 2025 order excluding the testimony of defense expert Michael Easter. This girl likes her red pen, so let me get the red pen out. And here we go. Now comes the defendant Karen Reed and respectfully moves this honorable court for reconsideration of the court's March 31, 2025 order excluding the defense expert Michael Easter's testimony regarding law enforcement's failure to adhere to standard investigative policies and protocols in this case. On March 31, 2025, this court allowed the Commonwealth's motion in limine, or as we call it, motions in lemonade because of the closed captions one day, to exclude defense's expert Michael Easter's opinion of the investigation. In so doing, the court explained that expert testimony is not needed because the defense, through zealous cross-examination of police witnesses, can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures. The defense respectfully requests that this court reconsider its decision in light of the fact that the Commonwealth only called 2 police witnesses. Oh, I pointed that out yesterday too. Gallagher and Buchanan, responsible for investigating O'Keefe's death in its case in chief. Canton Police Department Lieutenant Gallagher and Massachusetts State Police Sergeant Yuri Buchanan, both of whom refused to concede investigative failures. The defense should not be forced to adopt the self-serving opinions of these particular law enforcement officers regarding the reliability and adequacy of their investigation. Massachusetts law firmly supports a criminal defendant's right to challenge the adequacy of a police investigation through a Bowdoin defense. As the SJC held in Commonwealth v. Bowdoin, a jury may consider the fact that certain tests were not conducted or certain police procedures not followed to assess whether the investigation was deficient. Evidence of investigative failure may raise reasonable doubt, and precluding such evidence improperly removes this determination from the jury. Importantly, expert testimony may be introduced to support a Bowdoin defense where the subject matter lies beyond common knowledge. Such testimony is particularly appropriate where the expert can explain how an investigation deviated from professional norms, especially when based on articulated standards, such as departmental policies and procedures. The purpose of expert evidence under Massachusetts Rule 702 is to assist the jury in evaluating the significance of technical failures that may not be readily understood through lay observation alone. Point 1. Cross-examination is insufficient where the Commonwealth witnesses denied a failure to follow proper investigative protocols. This court's order allowing the Commonwealth's motion to exclude Michael Easter's testimony presumed that zealous cross-examination of Commonwealth witnesses would suffice to expose all investigatory deficiencies. However, as set forth in Commonwealth v. Reynolds, the defense should not be forced to accept the Commonwealth's witnesses' testimony regarding what constitutes standard policies and procedures based on what they are willing to admit. Moving on, there's some case law in there. I will scroll through it slowly because we are bumping up on coming back to court time, and you can read that at your leisure. Here, the defense must be allowed to introduce testimony affirmatively show how the investigative conduct in this case failed to meet accepted standards, not merely suggest as much through implication or adversarial questioning, particularly where here law enforcement officers failed, unsurprisingly, to concede that their own conduct was deficient. Roman 2. Witnesses' admissions of deviation from protocol opens the door to expert explanation of what the proper protocol is. Recent trial testimony has materially altered the posture of this evidentiary issue. Lieutenant Paul Gallagher and Trooper Yuri Buchanan each testified to conduct which clearly deviated from standard law enforcement protocols, but refused to concede any wrongdoing. Over the course of 2 days on May 5th and 6th, 2025, Lieutenant Gallagher testified to his account regarding evidence collection outside of 34 Fairview Road. Lieutenant Gallagher stated that he used a leaf blower to clear the area and uncover crime scene evidence, a method ripe with a substantial risk of disrupting or destroying evidence, was proper and effective in this instance. Further, he testified that because of the weather, it simply would have been impossible to follow protocols. He did. He thought they did a wicked good job because, it was snowing. Finally, Lieutenant Gallagher admitted that he chose not to search the home adjacent to the crime scene owned by a fellow officer, falsely claiming lack of probable cause and that it would be improper for him to attempt to obtain consent. Oh, he did. Remember? He dug into that, didn't he? That testimony was incredibly misleading, and there's a significant risk that jurors will give his testimony undue weight merely because he's a law enforcement officer, and lay witnesses are unfamiliar with the legal standards attendant to criminal cases. I feel so heard. Trooper Yuri Buchanan testified over the course of 3 days, May 8, 9, and 12, regarding his involvement in the investigation, and asserted that this investigation was conducted with honesty and integrity. All right, the fan is up, but the sound is not, so I'm going to continue until the sound comes up. The defense is entitled to rebut his self-serving claims. Trooper Buchanan admitted that he never entered the house at 34 Fairview Road to search for evidence, interview witnesses, or to photograph the home at 34 Fairview Road on January 29th of 2022. Furthermore, Trooper Buchanan failed to explain the divergence from the normal chain of custody protocol, noting that while certain evidence was discovered on February 3rd, 4th, and 10th of 2022, it was not written in a report until November 4th of 2023, almost 18 months later. He also fails to offer an explanation for failing to interview two potential witnesses, Ricky D'Antano and Heather Maxson, who were at 34 Fairview Road until over a year later. Furthermore, Trooper Buchanan admitted that there was evidence logged that he himself turned over where he could not identify who eventually filled out the evidence label. He claimed that there was nothing unusual with the handling of the evidence in this case. Proper chain of custody protocols are not common sense issues that are apparent to laypersons. The defendant is entitled to call an expert witness to testify regarding proper chain of custody protocols. The investigation in this case was clearly inadequate and deviated from standard policies and protocols. The defense is entitled to call an expert witness to establish that this case did not conform to standard or accepted protocols. The Commonwealth, therefore, opened the door to testimony by a qualified expert who can clarify for the jury what those protocols actually are and why these departures matter. Just as jurors are routinely aided by expert testimony, police regularly testify about information for which specialized knowledge would be useful, even if the information could be general knowledge for a certain juror. Thus, Ms. Reed should be permitted to proffer testimony from a seasoned FBI agent regarding investigative principles, policies, and professional standards. Michael Easter's testimony, rooted in the Massachusetts State Police Policy and Procedure Manual and decades of experience, falls well within this permissible scope. Point 3 is that the defense's right to present a Bowdoin expert has now become essential to ensure a fair trial. Fan is up, but they're not back yet. And I will scroll through this slowly so you can read it at your leisure. I just want to pick out some facts. The argument that a lay jury can adequately gauge the seriousness of Lieutenant Gallagher's use of a leaf blower or Trooper Buchanan's failure to appropriately comply with chain of custody protocols without the aid of expert testimony is unsupportable under relevant case law. Conclusion: Trooper Buchanan and Lieutenant Gallagher's testimony revealed significant investigative deficiencies, yet these law enforcement officers have asserted their investigation was not only adequate, but was conducted with honesty and integrity. The defense must be allowed to present expert testimony to place that conduct in context, explain its implications, and allow the jury to determine whether the deviations are material to assessing reasonable doubt. For the above reasons, Ms. Reed respectfully requests that this honorable court reconsider its order excluding Michael Easter's testimony. XOXO, Alan Jackson, Elizabeth Little, King David Yannetti, and Bobby Scissorhands Alessi. That was filed yesterday under her eye. Now we go to back to court. They're not back yet, but the fan is up. And people get very upset when they can't see the fan. Right? Like they say, I believe we're in court. Well, we are not. If you are ahead on another stream or you're watching it on a different channel, sometimes they are a few seconds ahead. The Court TV feed is not yet. And here we go.
You're welcome.
Put us back in session. You may be seated.
There's no patience, Jeff. Nobody has patience. The things I deal with on a daily basis. Oh, and Sheila, you've sent me 17 emails. You are not blocked in the chat. So I don't know who you are, but you are not blocked. So please.
All right, Mr. Relesi, whenever you're ready.
Thank you, Your Honor.
Contact YouTube. It may be an issue with YouTube.
Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities. And to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw.
That's huge.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee. And I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
No further questions at this time, Your Honor.
Oh, okay.
Oh, okay.
Could I inquire about scope?
Scope. Oh, he wants to go way outside the scope already. Already, he's trying my patience. My patience is tried. I'm on my very last nerve with this man today. I really want to know this too, roasted bean. So I held this. What does Liz have the blueprint mean? What does Liz has the blueprint mean? That was in the testimony yesterday in the text messages. One of Proctor's friends, and I'm not sure if it was misstated that one of Proctor's friends said that, and we were saying Liz is Proctor's wife's name, and that the witness, somebody pointed out that John Diamandis was the best man at their wedding. He knows who Liz is. What does that mean? Does anybody know? Jen told Liz the plan. Like, would that mean, yeah, like what the plan is? Liz knows the blueprint, like the plan. Like, I'm very curious about that. I was on Google, like going on Urban Dictionary, trying to figure out if there was some kind of, no, Liz is not Proctor's sister. Please do not put misinformation in the chat. Courtney is Proctor's sister. Liz is the wife. We deal in facts here. If you don't know, you don't know. You don't need to put it in the chat if you're not sure. There are so many people here who absolutely know the facts. Liz has the blueprint. And even Urban Dictionary couldn't tell me plan. So I'm thinking plan, right? Liz has all the tea about everything going on. And I don't know, because it was one of the friends that might have brought up Liz, right? Liz is the boss. Maybe Liz is the boss. Liz knows how it's going to get done, because it was right after the text messages about the girl's going to catch some serious charges, right? I think blueprint is another timeline. Yeah, and in fairness, wouldn't be surprising if more than one friend has a wife or sister or mother called Liz. I know, that's what I'm thinking too. And so I don't know. I wasn't dug into, so I just was curious about what it means. Like, if you say, like, in slang, is that like law enforcement slang, or is this just like somebody has the blueprint, like they know what the plan is? They know what they know what's going to happen. Oh, I see here. Kelly Denver, don't call me Dever. So they took the blueprint to mean she had all the background on John's history and family. That's interesting, but I don't know if I don't know. I'm just spitballing here. Does it not mean that Liz Proctor's wife is the boss in the relationship? I don't know. I thought about that too, Marley. Proctor's wife talked to Jen McCabe, like a lot of people thought that too, that she signed off on it. And I think that was the same. Was that the Jen? All right, now refresh my recollection on whether that was in the thread from January 29th or from February 2nd, which would be the day of her arraignment. Liz is friends with Chris Albert's wife. Okay. Thanks to Leslie's vocabulary. Right. He did say, tell them to send my wife the gift instead. So there may have been some, yeah, and why did somebody laugh at it? Somebody laughed at it, right? Proctor, I think, laughed at it. Ha. I don't know. I don't know. And I was just, it's one of those things that keeps me awake at night trying to figure out what it means. Right? Well, she didn't say that. She is not the one who said the gift thing. That was Courtney, his sister, who said, Julie said, when this is all over, she wants to get you a thank you gift. And he said, tell her to get Liz a gift instead. The blueprint is the plan, says track them cats. It wasn't on 129, says this doesn't corroborate. Blueprint means construction plans, how to construct. Well, yeah, but I know what a blueprint is, like in architecture, but I'm saying, is there a slang term for it? The scheme. Jennifer Baldwin, blueprint to me meant their write-up for how they were going to cover up JOK's murder. Yeah, see, that's what I was thinking too. That's where my mind was going on that. And so perhaps that will be dug into a bit more. We'll see. Thank you, Roasted Bean, for making us think.
May I?
Yes.
I don't think there's any
Dr. Russell, I
standard.
asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Lisi had you look at a couple of case files
Back to
from the
Lisi.
Journal of Legal Medicine, Let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question. So we're going to listen to the question, please.
Okay.
Those articles.
We're going to listen to the question, please. I'm going to need a chiropractor.
Whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alisi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alisi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Can we have Exhibit 1, please? Now, regarding the...
He wielded the highlighter.
Article. That was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
Yes.
And it was a neck wound from which she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom, penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. The way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites.
But is it made by the incisors of the dog? Dog's incisors make the scissor bite?
On that wound, are there?
I don't know. I see 1 or 2 things that shown up what I think might be upper and lower, so it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not...
There are no photos of the other side of the arm. Dr. Russell, point that out, please.
An accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity. I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so
Nope.
that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone,
There
on
were-
that wound.
Okay, there are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions.
Thank you.
There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However,
I'm just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
Vet girl, I just want you to know I put your
In the
super chats up a
highlighted paragraphs that Attorney Alisi had you
couple times, but you've been super generous today. So thank you so much for your 2 $50 super chats. You're the greatest.
read. That is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the, no, I don't agree.
I move to introduce this as an exhibit, please.
Is it an exhibit? Good. Introduce the entire article for the jury, just like you did all the text messages, just like you did the report of one of the defense's experts. Well done. Well done, Brennan.
210.
Well, it's an exhibit. I don't know if you're moving it into evidence. I guess we'll see. For the love of the traveling Mary. Are we behind it all? Scooch, scooch.
As well. Other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do
Do you
that.
see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
Thanks, LC McJD.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
You don't even know.
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived?
I'm sorry. We were here for season 1. That was your theory last time. We know, Hank, that you didn't even watch season 1, but that's been the Commonwealth theory throughout this entire persecution. Wow.
From?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor. So in the ER, I've treated thousands of motor vehicle accident cases. And most of the time, I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alisi, and that's why
She just
I'm
smiled.
pressing you on these issues.
Her smile is priceless. Dude, your experts don't even know how fast the car was going. And I know the jury knows that. And they're thinking the same thing. Look at the smile. I'm going to save that freeze frame for later because that's going to be tomorrow's or today's thumbnail, maybe when I go back. Look at that. Right on. Rock on. Rock on, Matron Saint in the Karen Reed trial.
Trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alisi, and that's why I'm pressing you on these issues.
Sustained.
Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So
Neither
when
were
you're
you.
asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about with these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event.
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr. Brennan,
Is that true?
I have no details about the collision.
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have any details that you know of other than what was told to you, correct?
Sustained.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise. It depends on the location. It depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard in the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, if as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, you know, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
No, the objection sustained.
When you came to your conclusion, considering what you see in this picture, and Attorney Alisi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor.
Sustained.
Finally, Dr. Russell, you said during your differential diagnosis, you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor.
What?
I'm going to allow that.
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Objection.
Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes a report in terms of physicians and what their possible experiences are. You know, do they work in a medical examiner's office in Alaska or, Hawaii or big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Yes.
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the Demunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of Attorney Brennan asked you, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin. And there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had.
Yes, thank you. So may I hand it to the witness?
Yes.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little
Yes.
bit.
Yep.
Just a reminder that this is not an airport and you do not need to announce your departure. Thank you for
Dr.
coming.
Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw it.
Commentary, and I'd like to be heard.
Why don't you bring the reports over?
I don't know. Susie Q is like, if I get something again, I'm going to lose it. I don't know how much more I can take of this either, to be honest. This is mentally and physically exhausting. I don't know who's up next. Has Lucky been spotted in the courthouses today? The day to get lucky? Bo Peep says, bring on the feds and put this whole thing to rest. I hope they go after those who are actually involved. Dr. Russell is going to leave skid marks When she gets off that stage, she's gonna lead skid marks and never, ever, ever, ever come back to Massachusetts. And it's a shame. She went to college in Massachusetts. And I think she likes Massachusetts. She went to Northeastern. She was the first woman police officer in the town of Malden, all the way back in the day. Karina Kolakithis, Officer Barrows, or Lucky could be next. Okay, I don't know who's been spotted in the courthouse today, but here's the sidebar, and we're looking at the fan once again. Thank you, Lori Viking. Toast via 20. Seymour Doubt. Oh, I like that name. Well done to you. Says blueprints equals she now has the blueprint to kill Proctor. Oh, I get it. Okay, that makes sense. Crystal Pond says what Hank is missing is the fact that the taillight is a smooth texture, not rough. The arm would have bounced off the taillight. Lori Viking Toast said blueprinting equals to plan to construct a blue wall. I don't know. Super CBD, interesting answer. I just Googled slang for Liz in police terms. Well, I'm not doing that because, Google search history is a thing. I don't know what it means. Mike O'Donnell, thanks. Lori Viking Toast, I think I just read this, unless you put it in twice. Blueprint equals blue wall construction plan. Don't know. Massachusetts, as a nurse practitioner, I salute you, Dr. Russell. Thank you. Thank you for explaining this nonsense interrogation, says Laura. Catherine wants to know what's the ruling of the missing witness charge. I just read the papers. That was just the papers of the defense. There has been no responsive papers filed by the Commonwealth, and so therefore there is no ruling yet. That was just filed yesterday morning. Did Dr. Russell receive copies of the autopsy report? Yes, she did. And she did consider that in her opinions. Kelly Denver says the blueprint comment came from someone named Whitey. Yes, I said that, didn't I? Not Proctor, but he liked it, right? Gail said, oh my God, this doctor's getting bullied. That picture shows all 3 lacerations, tears, and punctures that were torn up. Thank you for that. Kelly R said, if I were a juror, I'd be asking him, why the hell are we talking about a dog? Sherilyn, I'm so sorry that this is the anniversary of your mom's passing, and sending you all of the sympathy, vibes. Michael Geyer pointing out that Hank's father should have told him not to become a lawyer. Well done. I see what you did there. Well done. Storm Dancer says, Hank, did you know that those teeny tiny fragments could not cut through layers of clothing and do that damage to his arm? Dr. Strange needs to teach you some things about this reality. Yep. Seymour Dowd says, I don't think blueprint referred to anything nefarious. It was tongue-in-cheek, assuming Karen was guilty, that Liz now had the blueprint to do the same thing to Proctor. Yeah. Okay. So it was like a joke. Yeah. Okay. I dig it. I can dig what you're trying. I'm picking up what you're laying down there. Heidi, could Liz, the keeper of the blueprint, be Liz Albert? Is there a Liz Albert? AKA Colin's mom. Colin's mom is named Julie Albert. Heidi. Julie Albert. So there's that. Laura.
Yes.
Roasted bean is on me and my husband's
Russell,
account.
I am handing you this letter from Dr. Walsh. And what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank
She
you.
didn't say you are all set like she normally
I'm going
does.
to have this marked for identification.
Will Wallace pointing out that Dr. Russell obviously represents the better part of Massachusetts. I think she lives in California now. She's like, get me the hell out of here. Can I get an earlier flight? Hello, JetBlue? Thank you, Dr. Russell. You're a queen.
Next witness. And the,
If I may, Your Honor.
yes, just tell me the name because I need to know whether we need to go to sidebar first. Okay, thank you.
Oh, yes, it is Officer Nicholas Barrows of the Dighton PD. He's the one who met Proctor and Buchanan at Karen's parents' house and saw her car in the driveway, ass out.
So you're gonna step up?
Love this man.
Step up, face the
Do the
partner,
right
do
thing,
thing.
Officer
The
Barrows.
evidence you give to the court and jury in the case down here and the truth, the whole truth, and nothing but the truth, so help you God. I do.
Maybe see.
Good afternoon. All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barrows, Barros.
And where do you currently work?
The town of Dighton, Dighton Police Department,
How long have you worked for the Dighton Police Department, sir?
since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the detective bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Smiling if you're not watching your
Did you
screen.
know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dighton.
What were you asked to do? Why did you get that call?
The trooper said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual.
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to
Yes.
location?
Yes.
The other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dighton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger.
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barrows, I don't want the address, cameras are rolling. Did you respond specifically to a residence in the city of Dighton?
Yes,
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dighton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon, he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dighton to retrieve a vehicle that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day.
She's like,
And
slow down for the
guess I'm
court
going too
reporter.
fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever.
None.
Same with Trooper Proctor.
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes. Once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Oh,
Cool.
cool.
Were you in full uniform?
Full uniform.
Gun, badge, the whole works.
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there. And I also went in to ask how we're going to get the truck into the driveway because there was about a foot of snow.
That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between, longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that
Yep.
description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
There it is.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And
or so.
how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
Bang, bang.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked.
Here it is. Here it is.
Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
There again.
Can
There
you
it
do
is.
me a favor, Mr. Wolk, with the court's permission, could we zoom in on the right rear taillight, please?
Okay.
There it is.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barrows, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
Absolutely not.
What's different about this photo, sir?
That taillight is completely smashed out.
I'm not crying. You're crying. Somebody's
Does
telling
it
the
appear
truth.
that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence? Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
Wow. Boom
I'm gonna hand
shakalaka.
you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could
Praise
use
be.
one to your right, it's a little easier on the jurors.
Check it out. Come to your screen.
Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
Okay. indicating the
Yeah,
right
Coach.
side that wraps around the side of the right side of the car. That's the only red piece that was missing. The rest of it was intact. This witness saw it. He was there.
If the entire
An
taillight
honest-
had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way.
Integrity has entered the chat.
The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
We can take this down. As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have.
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen? Like, for instance, the SUV is taken away?
When I cleared from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is exhibit 105.
Here we go. This is the first time that honor and integrity have entered this
Do you
trial
recognize
on
this scene
the law
generally?
enforcement
I
side.
do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is diamond towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
Hallelujah. It's on the playlist already. The Jeff Buckley version.
If we could, with
in my
the
head.
permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Oh, Captain, my Captain.
Can we play this video?
Yes.
Thank you, Your Honor.
Come to your screen.
Can you see what's depicted in the
Yep.
still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area. This area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And
Yeah.
the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The
Picture
area that
speaks
I'm
for itself.
circling here, do you see any red lens in that area?
No,
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
absolutely not.
Thank you.
You said it twice.
Lights, please.
And the camera person focused on him instead of that photo that we've all seen 100 times with that taillight missing its entirety of it, the red. And the truth shall set you
afternoon, sir.
free.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dayton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene
Yes.
because it's your jurisdiction.
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it.
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you, you introduced yourself to them, they went into the Reed house,
Yes.
and then they came out.
They came out much later.
And that vehicle was towed.
Correct.
At no time from when you got there until you left, did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
He's there to protect the police right now, Hank Brennan. If you were wondering why he was hired, it was not for justice for John O'Keefe. He now wants this witness, the first person with honesty and integrity in this trial, who just told you that there was one piece of taillight missing on the side of that taillight. And now he's running defense, Brennan, for the cops. You didn't see them touch that taillight. You didn't see them do anything wrong. Wow. Just wow.
When
he's protecting them.
Vehicle was towed, do you know how long it took to take the vehicle from Dayton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
Really?
I could have.
In fact, there was no limitation on what you could.
You're going to blame this man because he didn't take a photo when none of your guys took photos? Now they're your guys because now you're defending Proctor and Buchanan from federal charges of evidence tampering. Oh, good luck with that, dude. Are you hoping that they're going to hire you as their defense attorney when the federal charges, when the feds come marching in? Is that what you're hoping for? Good luck.
Could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at that moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill? You didn't say that, did you?
No.
Or that it was 3 to 6 inches? You didn't.
He was also not investigating a murder. None of your cops put the busted taillight in any of their reports, did they? Yeah, I don't think so.
Didn't mention that, did you?
No.
You didn't mention the placement of where the damage was?
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
Wasn't asked.
I don't think I was asked that.
What were you asked about to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
Read the question and answer.
I don't think I was told to describe it in depth.
Will you ask questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed,
Time has passed, yep.
that you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed,
Correct.
that your report was respectfully scant,
Correct.
that you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, is the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson,
Did you speak to him in person or on the phone?
in person.
Okay, don't. Okay. You're not hesitating, are you?
No,
Where did you speak to him in person?
at his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel to speak to them about a case.
No,
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Who
Not
else?
me.
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end.
The,
The good-looking one down there on the right.
no, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No,
When you were in that conference room, were you shown your police report?
no,
Were you shown your testimony from the last time you came into court?
no,
The photograph of the vehicle in the Sally Port, or the vehicle with the missing glass, were you shown that?
no.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen in Dayton.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
I don't think he was. I don't think that came up at the last
You
trial,
said
actually.
That photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged. It was cracked, and there was a piece missing, but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
He's a solid witness. You can try.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
I don't think you've shown that photograph, to be honest. I don't recall. But I'm sure he's going to try and poke some holes in his testimony, but
Any approach?
I don't know that it's going to work. We love you, Officer Barrows. Thank you for doing the right thing. Pee-wee trying to slip him up.
Sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo.
He wasn't shown the photo last time. I that's the way I remember it too.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
He's focused. He's pointing to a photo that's on the screen, and I don't know if it's the photo of the car getting on the tow truck or the photo of the car in the drive. I don't know which photo he's
Let's
talking
take a
about.
look at there. Could you show me anywhere in your testimony? Anywhere. Where you made any statement about that photo being inconsistent with what you saw in Dayton on January 29th, 2022.
Oh, it's the Sallyport taillight photo. He might have seen it on the news. He might have seen it. No, because Lally did not. Neither side prepped him last time because nobody knew what he was going to say, and that's why the defense did not dig into it further to ask him, "Can you describe the taillight further?" Because they didn't know what he was going to say. And now that he's cooperative with the defense and he wants to tell the truth because he sees that a woman is being railroaded, facing life in prison, he's having him read his entire trial testimony. Ed Wallace says he didn't do the right thing. That was Kelly. He's doing his job with integrity and honor. That's right. I don't think it's going to matter.
It's not in there.
Can I approach?
Yes.
He was never shown the photo.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy, they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade, right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath, you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah, correct.
And you share those same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, you're to say that never happened.
Correct.
You were simply mistaken, weren't you?
He was mistaken about not being shown the photo at the last trial. It's the only thing
Correct.
he's mistaken about. Because he didn't say that last time. Because if he did, she would have been acquitted.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about? Objection.
I'm going to allow it.
Over here. What did you talk about? Excuse me.
So that, okay.
What'd you talk about? You could have done all that over the phone, couldn't you have? Will Wallace, Hank, have we ever met? Good cop, no. Because Hank doesn't know good cops. I've heard enough. Case closed. Do you think it's going to be fatal to his testimony that he said that they showed him that photo at the last trial and they didn't? We know that they didn't, because I remember they didn't show it to him. Nobody knew what he was going to say. He said it was cracked, not completely damaged, and nobody dug further into it. Here's the fan. Never.
You told us there was some background about being subpoenaed and time. Substantively, what did you talk about with the attorneys when you met them at their hotel conference room?
Other than that, they didn't go over my testimony. We just spoke about that. I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No,
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably June, early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably? Or do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV and.
Was
Yeah,
it shown
TV.
to you during your conference room meeting at the hotel?
It was not.
So you looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you, I'm just asking you. Have you been exposed to this case since you made those observations indicted on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory? Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay.
Approach. Proctor's dishonorable discharge is here with Chaka as his or her profile pic says, been away all AM. I'm on jury duty in Canada, King's Court. So nervous. Please pray it's nothing like this trial. Replay queued up now. I love you, Halama. Legal onlooker. Why does Hank Brennan always recross about more than what's covered in redirect? And why does he get the last word? Isn't redirect last? Cannot stand. Team Hank Brennan. And BC. This is the land of the upside down, inside out, lost Hunger Games, Narnia of Norfolk County Superior, and there are no rules. It is worse than a kangaroo court. And so I can't answer your question because there's no rhyme or reason to what goes on here. But thanks for your super chat.
You've seen
They have unlimited funds,
quite a
Susie,
bit of
yes.
information about this case and the issue regarding the taillight since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
would you agree that you have some difficulty with the amendment?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it in Dayton. If we could have
Titan?
the ring video at 5:07.
Caption said,
please.
oh yeah, no, because you can't see anything from that ring video. I would show a picture of an exemplar vehicle with the way the taillights look when they're not completely shattered. You could do better. How about a picture of the exemplar vehicle that your expert paid for and bought that he wants to sell in California for a profit, but he can't because of the emissions laws
Have you seen this video before, sir?
I have.
on TV,
Before you-
like everyone else.
Have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Everybody in the world has seen it.
In this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look compared to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. Who's right this way?
How about I saw this woman was being railroaded, and then I saw on social media the picture of this completely shattered taillight and what happened after I testified, and I knew she was being railroaded, and I know that that's not what I saw.
Stop, please.
Can't see anything.
Do you see that white part of the back rear right taillight? Objection.
Yeah, objection. You
I'm
can't see
gonna allow it.
anything in that video.
See that? Sir?
On the side of the vehicle.
Can we zoom in a little bit more? I can.
Can or cannot?
I can.
It could
CA
be
can?
totally
Yes.
photoshopped.
Continue, please.
I can't really see it. It's pixelated. I mean, people have pointed this out that have done videos on this, and they say that it's.
Back more.
I still see a lot of red in the back.
Open, right there. Zoom, please.
Glare,
You see, sir?
the snowflake.
Sir?
I can see that.
Changed mid-frame.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Where's the metadata?
Can we go to?
It's a reflection of the overhead
Exhibit
light.
10, please. And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day.
Yes.
And when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing.
Yes.
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus in Dayton, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, we have Exhibit 11, please.
The wellness check video that you can't see how it doesn't bump out the way the other one does.
To the right,
See?
you see that right tail light, the white part
I can.
missing, yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
There's
This
snow
is
on it.
before you saw the car in Dayton? Do you know that or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear taillight in the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Can't see anything from that photo.
Yes.
I have no further questions.
Okay, lights on, please, Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain us to the form, Mr. Jackson, is
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dayton, correct? Being called out to Dayton to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Remember it was this lady, pretty lady right here in the blue?
I do.
You remember meeting Mr. Reed?
It's Mrs. Reed he was pointing to.
Handsome gentleman with the gold tie?
I do.
You remember all that? Right?
Mhm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
Yep.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dayton while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD? I'm sorry, in Canton, in the Sally Port at the police station
I wasn't.
at 5:30 p.m.?
Objection.
Sustain.
At any point, did you ever go to the Sally Port at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sally Port?
Objection.
Sustain.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
Objection.
So that's stricken, it's beyond the scope.
He did testify for the Commonwealth. It's out there.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken, correct?
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Nefarious.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Yes. Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
Keeps moving away from the mic.
You would agree that your memory has changed since last time you testified in this courthouse?
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dayton on January 29th?
Can't see anything in the photo.
Objection.
I'm going to allow it. It was opened
That's
up.
not evidence.
It was opened up.
Is it consistent with what you saw on January 29th, 2022?
It is.
Thank you.
All right, Sergeant, you are all set. So
Thank you. We don't know what that photo shows, so if it's consistent with that photo,
All right,
You
so
can't see what that photo
jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than doing it out witness. So those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day. We'll finish by 1.
tomorrow's half a day.
All rise for the court, please. Close your notebooks and follow me.
Vet Girl, thanks for your another super chat. Doesn't your memory get sharper when you feel that something is wrong? Gut instincts? He's a trained observer. He's a police officer. He has no connection to anyone in this case. He's really the only guy with no dog in this fight. And he said, that is not the way the taillight looked when I was at the back of that car in Dayton in the driveway for at least 20 minutes. What say you? Ashley says Hank is nefarious AF. Thank you.
Jurors exit the court, please be seated.
So there have been some motions, I think, piling up.
We talked about two of them.
I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Gianetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time. I just don't know what you're talking about. Sure.
Taj Mom says, did the tow truck driver photograph the vehicle? We don't know. He's on the witness list. I don't know that he's spoken to anyone. I don't know what happened last time he was on the witness list. I don't know if he was unavailable. I don't know if nobody could find him. Dr. Russell just did an autopsy on Hank. He says, Michael Powell, and hashtag false memory. The lights in Alexa's are red. That's why it shows red, not just the plastic. That's why it's hard to tell in the videos. However, looks like the piece is missing to me. I used to install taillights for Ford for 30 years. I don't know which video you were talking about, the one on the tow truck or the one in the driveway. But also know that none of these videos have any metadata and none of them have been authenticated. And there's a lot of other shenanigans going on here. Thank you, Gladys Kravitz. You're not alone. I cried. Thank you, Officer Barrows. All right, we'll see if we're going to hear any more from them today. And then tomorrow we have just learned that it is half day. Thank you, Janine, for 5 matcha lattes. I appreciate you very, very much, as I appreciate each and every one of you who chooses to spend your entire day with me. Susan, thank you for your very generous Venmo with a little emoji of a present. Thank you so much. Nurse Jones, Hank's father should, I'm not going to read that. Thank you so very much. That's funny. Karen, thank you for your thank you. Steven, can you talk about the difference between Dr. Russell and Welcher 7 versus 20 feet body? I don't have time for that today, Steve, and I don't, it's so convoluted, but thanks for your 5. And if you can just refresh my recollection tomorrow, you don't have to do another super chat, but Welcher really didn't give any measurements of where John O'Keefe's body was. And Dr. Russell was told that it was 30 feet because in trial 1 in season 1, which Dr. Russell testified at, the theory at that time was that his body was 30 feet from the street, but nobody ever took any measurements. Nobody ever did anything. And Welcher said 7 feet because that's what the Commonwealth told him this time, because quite honestly, they just keep changing their theory all over the place. Every time you turn around, it's a different theory. Thank you, Jonas, for thanking me. Denny Cakes for your matcha latte says my dog Sammy is watching the trial with me. Shout out to Sammy. Kaylee, just want to tell you how much I admire your intelligence, wit, and humor. You've made a frustrating and corrupt case into something palatable and educational to watch. Thank you. Thank you for watching. Tell me what you think, guys. What do you think? Do you think that Hank Brennan was able to poke holes in Officer Barrows' testimony? I want to point out to you something else, which didn't come up, and I didn't highlight this comment because I didn't want to, give Brennan any ideas. But now that Barrows is off the stand, he was in a near fatal motor vehicle accident. I don't remember when it was. Somebody put it in here. Patriotic. He was in a near fatal car accident on October 9th of 2023. We're so lucky he's here to tell the truth. Read something in the cesspool of Twitter the other day that it may or may not have been around the time or even the same day that he testified in front of the federal grand jury. And I don't know if that's true or not. I need to do a little more deeper dive into it. But if that is true, that is frightening. What happened to I think it was a woman who was in that near fatal car accident with him. And I remember when you guys brought this up, because I didn't start covering this case until January of 2024. And so that gives me even more pause and makes me go, Susie wants to know, do they have unlimited funds? How do they afford to keep prosecuting this case? Yeah, they do. They have unlimited funds. They are so dug into this case that they're never, ever, ever, ever going to give it up. They've had a lot of major cases in the news the past few years. Who pays? The Commonwealth of Massachusetts pays. The taxpayers pay. They hired Hank Brennan. He's a hired gun. There's no conflict here. They didn't need to hire an outside prosecutor because there are 50 district attorneys that work in the office of the Norfolk County DA's office who are on salary who could try this case. Adam Lally is one of them. I call it the hot potato case in Norfolk County because nobody else wanted to touch it or try it. And so they hired Hank Brennan. I don't know what their reasoning was to do it. There's no conflict here. And they're going to pay him by the time this is all over, something like $1 million. They told the taxpayers originally it was only a $75,000 contract at $250 an hour, which is what plumbers make in New York City. And we none of us could figure out why the guy who represented Roy D. Bulger and probably makes who knows how much an hour as a defense attorney Compare and contrast that to someone like Bob Alessi from New York, who makes upwards of $1,800 an hour, who's working for free here. Why would he do it? Why would he take this case? Fame, fortune, political aspirations? We still don't know, but the taxpayers deserve to know why nobody else in that office would try this case. And Monj, if I could jump up and down or even do the jig, I would. Thank you, Officer Barrows. Leah Atkinson, thank you for your 5. So I want to hear from you guys. Do you think that Hank Brennan made him seem like he wasn't telling the truth? Because he testified that at the last trial, he was shown that picture. And he did say that's not what he saw. Because, you know, we've all been inundated with social media since this case was tried. The mistrial was declared on July 1st of 2024. It's been almost a year. So he's seen that picture of that taillight somewhere. Do you think that was fatal to his testimony? Maybe he was shown it at the grand jury, right? Maybe he was shown it at the federal grand jury. Marcia thinks Brennan's questions made Brennan look like a tool. Larry 70 says, I think he poked a couple holes, but he didn't shake him from the truth. Peggy says the whole state of Massachusetts is run by corrupt criminals. Day says no, he wrote a report. The tow video speaks for itself, says Mimi. April Dawn says not at all. He was definitely one of the few genuinely honest witnesses. Barrows saw what he saw. Yo Kelly says no, Hank blew it. Barrows was golden. Okay, good. Okay, good. He had a false memory, says not guilty. Kat says they don't think it looked great. Another Kathy Smith says, I think Brennan is so smarmy and people have to see it by now. They're still at sidebar. Flamingo Chicky said Hanky did nothing to the good officer. Judy girl, this is such a relief. Had a bad stomach ache after Brennan's DNA interjections from this morning. Now I have a headache. I had a headache when we first started. It's resolved itself by now. But Dr. Russell was on the stand most of the entire day. We had a wild, I can't even remember now if it was at the late morning or after lunch, motion for a mistrial when Hank Brennan pulled out the questions about the dog DNA. Unless he argued you didn't bring out any evidence of dog DNA on your case in chief and you shouldn't be allowed to argue it now and you can't put the toothpaste back in the tube or the genie back in the bottle and the case needs to be dismissed with prejudice. But the judge didn't agree. DB, hail Dr. Russell, true OG badass. Tracy says, I just wish he didn't say he saw the pictures last time. Hank was all over that, and I hate he uses that to disrespect people, talk about witness intimidation. Kindergarten cop, cheers. Dana, what about his Apple Watch showing him go to the basement and that's it? And the fact that they redid the basement and are selling the house, even rehomed the dog all the way to another state. Wise gal, did Hank try to trick him from switching picture from Reed's driveway to the picture in John's driveway? Good question. Timothy, wait a second. I see something here. Sorry, Timbo Plymouth says, no, I think Brennan was trying to fool him and failed. As soon as he said the taillight was damaged but not completely missing was all the jury needed. Hank failed. Okay, good. Okay, good. Track them cats says Officer Barrows came across as honest. Hank is a reaching bully. Hank's little Bulger says the public has more money than they do. And Marcy is up for re-election next year. Norfolk fools will probably re-elect him, though. No, I don't think so. I don't think he'll be re-elected. I don't think so. BN Trouble 31, who's done a lot of work on this case at his own expense, says if the tail light was completely busted out, then there would be salt, water, spots, and or sand inside of it. Ash RL says as a former schoolmate of Officer Barrows and a Dighton resident, he has done his proud. Yes, he has. He has. Props to Dighton, and your police force is amazing. You know who else's police force is amazing? Dover PD. Dover PD is amazing. They did the investigation into Katie McLean, who was killed by Dr. Harry Turk. And some of those officers at Dover are amazing. So feel lucky if you live in either one of those places because according to it could be anybody because it's stuff, says Nicholas Barrows, is a king of law enforcement officers. Thank you, silly girl. Kathy's Crafty Life says, I think Officer Barrows is a good, honest guy with honesty, integrity, but I also think Hank may have been able to poke some holes into his memory. I just pray the jury has critical thinking skills. Same. We have learned tomorrow will be a half day. And we have also learned that the next witnesses to be called in no particular order that I know of are Lucky Loughran, the plow driver, and Karina Kolakithis, who was a friend of Karen and John's that was at the waterfall, who I thought was a very positive witness for the defense last time. Thank you, Betsy. I love you too. Thank you, Lori. Tears of joy for our hashtag Truth Daddy, Officer Barrows. I mean, that took guts for him to come in and testify and tell the truth. And we're still waiting to see if anything is going to be said in open court. Thank you, Rowan. This is Free Karen Reed. Ashley. I did thank you already, Ashley. Thank you. And so there's an article about Sergeant Nick Barrows, who, so October 9th of 2023, he was hit head on by a drunk driver. Says he's lucky to be alive. His cruiser was mangled. Oh, there's pictures of it. I don't want to pull this up. Thank you, Patriotic, though, for sending it to me. Thank you. Wise Gal 81 says, Hank highlighted everything his own witnesses should have done but failed to do. Also showed his witnesses fibbing about their memories getting better. Marcia thinks Barrows was great. How do Brennan and Bev sleep at night, says Crime Mom. So disgusting. He said the only piece that was missing was the piece on the side that wrapped around the right side. And he said, yeah, and that's exactly what I see in the video of her leaving the driveway in the morning. Ain't no rest for the wicked. Just imagine, says the piece that Nick Barrows described as missing was significantly smaller than the smashed up taillight. Win for the defense. I mean, if that's what he says he saw, does that lead you to the conclusion that the rest of the taillight had to have been planted? Why is Allie McCabe there? Where's Allie McCabe? I don't see any Allie McCabe. Ain't no Allie McCabe. She's talking about, you know, when I saw that, I thought of Allie McBeal. Remember that TV show? Allie McBeal? Christina Pfeiffer says Barrows makes Devers look disgusting and disrespectful. Everyone is so still in the courtroom that I have to like see if anybody's moving to see if I'm on a freeze frame here. Wise Gal says today proved that there is zero chance all those pieces were planted at 34 Fairview. Deborah Sick of Brennan did nothing but make the Commonwealth look more suspicious. Jem McCabe's sister is there today? Yeah, I don't know about that. Is she? Precious Peeps says the photos and video are clear to me and evident. The right taillight was missing just one piece. You are all set. Could be anybody because it's stuff, says the jury smells a cartoon character in Brennan. Pamela Bailey Point said, I'm a couple hours behind because I had to have my first colonoscopy. After I woke up, the doctor said I'm full of poop and it has Hank Brennan written all over it. That's hilarious. You shouldn't like hallucinate that in your post anesthesia haze. That's hilarious. I think I was able to get to all of the other super chats today. I put everything up on the screen pretty much. See if she's got anything to say before they wrap for the day. Just a reminder to get over there and sub up and like the videos of Duty Ron and Ed Wallace. They entertained you during lunch with at least half of their live stream last night that I played for you. We went over to new motions, the one to reconsider the testimony of expert witness Michael Easter, as well as the one for a missing witness charge on Proctor, Higgins, and Brian Albert. Just say no to Sideswipe volunteering. Says, is the defense going to pull out the missing piece from Dighton like a scene from Cinderella? The defense, mean DF? Is that what you mean, defense? All right. And Court TV is wrapping. As are we. What a day. What a day. I have to digest a lot more before I can even speak any more of it today. But I think we tried to digest everything and comment on it in real time because that's what I like to do. That's why I stop. That's why we pause. That's why we talk about things in real time. And so I'm going to digest everything a little bit more before we talk about it. And great, what a day. I'm exhausted. You must be exhausted. Thank you to the, no, I can't join in. I'm exhausted. There's nothing more that I can do on the air today. Thank you to the moderators for keeping it classy today. This was not an easy stream to moderate because there was well over 23,000 people in the chat all day long. You guys are amazing. I love each and every one of you for choosing to spend your day with me. I am so, so grateful that you choose to spend your day with me when I know there are plenty of places that you can watch your coverage. I'm going to be on WPLR tomorrow morning, 99.1. It's a Connecticut radio station at 8 a.m. So if you want to tune into that, I think you can get it. I think it's PLR. It's the morning show. I can't even think right now. At 8 a.m. I think you can get it on the internet, on the interwebs. Thank you everyone for doing all of the things, liking the stream, sharing it out, commenting respectfully, being you. You're amazing. Stay cool, stay kind, stay classy. Until tomorrow morning, I will see you very, 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 very soon. 8:55 a.m. tomorrow. Listen for me on 99.1 in Connecticut in the morning. It's a morning show on the radio talking about Karen Reed. I will stay cool, stay kind, stay classy. I love you all. Red's daughter, thank you for the last minute super chat. Chaz and AJ in the morning, thank you. Red's daughter, at least he didn't have a false memory. Hank only proved he's human. And we don't all remember exactly what's said, but we remember what we see. We do. See you all tomorrow, my friends. I love you with all of my heart. Thanks, Jen, for your super sticker. Good night.